Yang berbahagia Dato' Amalina Sharmila binti Dato' Dr. Johan, Solicitor General 1 of Malaysia, esteemed speakers, distinguished guests, ladies and gentlemen. A very good morning and warm welcome to the Asian International Arbitration Centre, or more commonly known as the AIAC. My name is Ragini and it is my pleasure to serve as your MC for the day. To begin with, we would like to take this opportunity to express our utmost gratitude to our collaborating partner, the Legal Affairs Division of the Prime Minister's Department, BAYU JPM, in co-hosting today's workshop, and our supporting organizations, the Inns of Court Malaysia, the Malaysian Institute of Arbitrators, Chartered Institute of Arbitrators, Malaysia Branch, and Borneo International Center for Arbitration and Mediation, BICAM, for your unwavering commitment and support. Today's workshop marks a significant stride in the Malaysian dispute resolution domain, specifically in arbitration. This signals Malaysia's commitment to engaging in thought-provoking discussions in line with our overarching efforts to legalize and regulate third-party funding practices in Malaysia. Ladies and gentlemen, I would like to take this opportunity to inform you of the slight change in today's agenda. Due to unforeseen circumstances, Yang Berhormat Dato' Sri Azalina Othman Said will be joining us later in the afternoon. Distinguished guests, ladies and gentlemen, to kickstart today's workshop, we would like to invite Mr. Philip Koh Tong Ngee to deliver the expert presentation entitled Key Issues and Challenges Arising from Third-Party Funding in Malaysia. Philip is an adjunct professor at Faculty of Law, University of Malaya, and a senior partner at Mahkamaria and Philip Koh. He completed his LLB at University of Malaya, LLM at King's College London, and Masters in Theology at Australian Catholic University. Philip is the Vice President of the Law Alumni, as well as the Trustee of Tun Sofyan Foundation. Philip's career and work straddles the academic, professional, regulatory, and business worlds. He writes on constitutional, contract, and corporate law. He's also a member of the panel of arbitrators here at the AIAC. Let us welcome Philip. Over to you.
Thank you. Thank you, Madam Chair, and very good morning, Yang Berbahagia Dato' Solicitor General. Thank you for attending this opening session, and all these brave and resilient souls that wake up early morning and come, even though not that early, it's already 10, all right? We should be awake. I don't know about this myth of an expert opening a session like this, all right? I call it a myth because many of us claim to be experts. Of course, they are true experts in this hall, all right? And certainly, I'm no expert in this. So it's a bad opening, they say in speech, to say you are not an expert in the area. But I say this not as a disclaimer, but truly, we are wrestling with fascinating issues, all right? Issues that is part of our legal landscape. Let me just say that because we think that, oh, third-party litigation funding, is it some rare species of some thing that, oh my goodness, it's a Suluk Island, all right? This wretched third-party funding group that wreak havoc about claiming how many billions from Malaysia. Let's not go near that. This whole topic, all right? It's a taboo. Don't go near. Is that a right attitude? Are we not ostrich in the sand, thinking that you will go away? Is not some of our very practices in Malaysia, in the legal profession, and I say this not in any criticism. Many of us will say, well, Philip Koh, you know, you live a lovely life, you work in large firms, you work in commercially wonderful firm with lists of clients paying you good fees, all right? You don't know how hard it is for us to have a client and who can pay us, all right? These issues are part of who we are. Whether you face in a hospital a running down lawyer or a tout coming to you and say, hey, madam, we can help you claim, all right? Or a big shot insurer will say, what, you have a negligence suit? Don't worry, we have a battery of lawyers, and we will fund the lawyer. I mean, isn't that part of third-party funding? I mean, these are variants, all right? I'm saying this so that we do not recall away from the fact that third-party funding is a bad word. Of course, the very fact that there is a seminar devoted today and tomorrow, and the title of it is Charting the Path Forward. I'm glad whoever dreamed of this thematic, I think, is touching a right nerve. Yes, it is right to condemn unethical practices. It is right to say the Tridium of this world or that third-party funder who funded the Suluk, maybe we demonized all of them, all right? But the narrative is a much more complicated one in the legal landscape. Today, I'm going to just share some of the key issues. I have no answers to those issues. As someone who is devoted to law teaching, my first love is law teaching. I'm always considered too academic. I don't know how I survive in the marketplace. Maybe I promoted the myth and I'm an expert, so some people believe me, okay? Sometimes you have to promote yourself. But as a law teacher, I would say, until we ask the right questions, until we encounter the difficulties in navigating a terrain and are puzzled, how are we to find our path in this maze, landmines between ethical obligations, legal integrity, calling as a lawyer, a vocation that we are lawyers and we are not just businessmen. Is it true? Or has law become a commodity? Has justice been part of just who can pay? These are the endemic issues, and I can only highlight some of them. I thought that perhaps that's my role. Some of you have listened to a part of this presentation before, and I'm sure you will say, oh no, why did I come again? All right, please forgive me, because when I'm invited for this, I did tell the organizer, look, I don't think I can update my not so sexy PowerPoints, all right? But here am I. Here I shall try and engage your hearts and your mind in some of the issues that I consider on third-party funding. This is too small, but my whole framing of it will be, first I give a background, the global phenomenon, then the legal framework, then I talk about some of the funding scenarios, then I talk about historical context. Why? Because I think without understanding our history of the bar, we cannot proceed. He or she who wants to be a pioneer must first understand your background. Many of us don't care about history, but history determines the fault lines of many of our decisions, isn't it? Whether in politics, in culture, in religion, and in our way of life, in our profession. These slides will be sent to you all right? I'll tell the organizers. And then I talk about the funding, the principles of legal profession, about prohibited practices, which will be reprised again, the topic I understand looking at the program tomorrow in a major session, which you should attend, because the detail will be more teased out there on jeopardy maintenance, then legal fees as damages and costs and etc. and conclusion. So certainly my talk does not pretend to be that comprehensive, and I will merely be someone that will open up, I hope, the contextual landscape of which we practitioners, and I will include, I can see many of my good friends in the industry who are not lawyers, but far cleverer than lawyers, all right? Engineers, quantity surveyors, construction specialists. You are part of this stakeholder, especially in the arbitral environment. In fact, the first session that I had about a couple of months ago was chaired ably by Tan Sri Arif Yusof. I was joined by Malik Imtiaz and the Hong Kong specialist, Teresa Cheng, and also a specialist third-party funder from Europe online, of course. That was a fascinating session for me, a great learning curve. Here we are, third-party funding gained its notoriety or repute in the so-called Suluk Island arbitration, which I already alluded to. I'm not here to talk about that, and merely to say that that has created an image of third-party funding as if it is something to be demonized, something to be avoided like plague, all right? But we cannot do that merely because of what we would argue is an abuse of third-party litigation funding in that instance. Then we would ask about the three major facts, all right? What about our own Legal Profession Act? It is critical for us, especially I'm addressing the community led by the Bar Council and the local bar. We need to ask hard questions about the Legal Profession Act and about our practice and etiquette rules. What were they part of? What were the legacy that we inherited, the virtues and the values that are reflected in those rules? All very laudable, all right? Not something that we want to say sniff at, because we look at, I call it the myth, the word myth, that the legal profession is a profession, not just a business, all right? We then turn our nose against anything that smack that it is a mere business. This tension is played out in this whole issue of third-party litigation funding. Do we then leave third-party funding to the vicissitudes and accidents of court decisions? I will be able to show you some court cases, and the PowerPoint will be sent to you all. Those who are interested, do navigate those cases for those who are lawyers. And I must acknowledge here Justice Su Tiang-ju, who is now confirmed as a judge, a very able lawyer and now a very able judge. And in a presentation in the International Malaysian Law Conference, I listened to him on this area, and I was fascinated about the body of cases that he could call up, showing the range of court decisions reflected in this whole issue as we navigate on issues of touting, championship maintenance, and third-party litigation funding. So I will touch about a bit on that in the three main terrain that I shall be sharing with you all. Case scenario, and here I want to acknowledge my partner, Kamaraj Nayagam, who ably teased out for me, but actually he was very playful. He said, we should start this session by playing a song called Bob Dylan about How Are You, Marie, or whatever. I mean, I must give you the title properly. And if you want to be outside the law, then you must be, Are You Here Tonight, Marie? I mean, it's quite funny. That's Kamaraj. Someone say Kamaraj, which is so funny that you have to pause for a while and say, what are you saying, Kamaraj? So anyway, he helped me with this case scenario. A client comes to a lawyer with a claim. Oh, that's normal, all right? That's what we are here for. A client comes knocking on our door, sends an email to us, referred to us by someone. The client states that he has no funds. No, this is not untypical, unless, as I say, you are in a fairly medium-sized firm like mine, and most people come to my firm, they would have some funds. Otherwise, they will probably be shown the door, unfortunately, okay? And maybe even they won't come in because it's like, wow, so intimidating, right? Well, not my firm, but some firms are pretty intimidating. To go up, you have to go to security, and there's a huge welcoming area. You don't feel very welcome at all if you don't have funds, all right? So the client says he has no fund, normal. The lawyer agrees to conduct the matter at an agreed fee. But he knows in the case of an impecunious or commercially weak client, or a client, not just necessarily that poor indigent client, all right? Reading some of the materials that are available now, there is a very dramatic case, all right? Family law case about a Russian oligarch, divorce, family law, all right? Where the poor divorcee, all right, the lady petitioner won a case, but to enforce it, she need millions of pounds to pay Queen's Counsel and King's Counsel to pursue and enforce the order. And of course, the oligarchs can afford, all right, expensive King's Counsel to resist. How is the helpless divorcee to enforce that against a rich client? We don't have to go so far as in England, Malaysia. We know, all right, even within our own midst, family law fights where the lady, normally the lady, okay, yeah, let's say that, all right, would have a hard time fighting against a rich tycoon husband, all right, who has a battery of lawyers. How is she going to pursue her rights without litigation funding? And the family court in England ruled that the whole issue of championship and maintenance ought to be re-examined in the light of that. We should not strike down such arrangements willy-nilly, as one Malaysian case seemed to suggest. Section 24, that's my favorite area, Contracts Act, illegality and against public policy, all right? We all know this is undergraduate contract law 101, my favorite passion when I was a young man. Contract law, public policy is an unruly horse. Is it public policy to keep financially unable clients making an arrangement that might help that client to pursue her sense of justice and injustice? Is it necessarily against public policy? These are issues which are endemic, as I say. So the lawyer in that scenario then say, okay, I conduct your matter at an agreed fee. He knows that the fees may not be likely to pay if the case is lost. Again, that is normal in the line of thinking, all right? So what can the lawyer do to try and accommodate? Or a client will say, I can prepare to pay you only 20,000 ringgit for a start, but after that, can you work out something where contingency, success, all right? These are variants that we will find that we need to navigate as we think about third-party litigation funding. What if the lawyers agree to bear all the costs subject to reimbursement? This is maybe unusual, but is it wrong? Let's have a look at it later when we look at the Malaysian cases. Hopefully, it will shed some light. Sometimes it shed a bit more complexity. As we all know, when we read cases, there will always be another case to say, well, then we have a federal court case now, which I will try to draw your attention to, which is interesting. And then there's the arbitration environment. I know we are in AIAC and some of you are more in the arbitral environment, but my conversation in this matter does not only touch about third-party litigation funding for arbitration, but on the whole, when legal profession is involved. The client does not have financial capacity to bear the fees. The lawyer even advances the fees. The lawyer himself, all right, sponsor the litigation as part of agreement that it may be reimbursable as costs, as I say. That is again unusual. The arrangement then comes to the attention of the respondent, who then obtains an order of security for costs. He realized that if there is a very deep pocket respondent, he will intimidate your claimant with security for costs, all right? And often that can be pretty high. And again, that is normal. The clients then obtains funding to pay for the security for costs. Sometimes they have to scramble and ask their relatives. But what if you go to a third-party funder? All right, that is then how this conversation will proceed. Can the lawyer stand surety for the security for costs? There could be trouble, T for trouble, all right? Because you are now trying to guarantee you are staying security for the cost even. What if the client's funding is secured by assignment of proceeds of the award? Even more query, all right? There's a query there. Because even the Suluk Island, it is conjecture we cannot validate, all right? The original third-party funder has originally assigned it to other parties already, all right? So you can have this issue of assignment. And then it's not that completely alien, isn't it? Because if you look at some insurance-backed claims, there could be either an assignment or novation of the proceeds, not wholly, of course. At the end, the claimant can get some money. There are some arrangements like that, even in our normal legal transactions. Before the rise of this whole topic called third-party litigation funding, we must reflect on the past. The Malaysian bar is a product of the colonial and post-colonial legacy of the English bar. We are well aware of that. That's why the Inns of Court has co-sponsor even this, collaborate this session. And it's interesting, in our mother England, all right, so-called colonial forebears, they have recognized third-party litigation funding. They have created a federation, a body to self-regulate and to promote the code of conducts. These are all part of the topics that, for all of you who persevere to attend the whole session today and tomorrow, you will be exposed to those topics. So I'm here to give you the teaser, okay? But I would like to just acknowledge that even our colonial forebears have moved on, but we seem to be paralyzed in the 19th century or early mid 20th century model of how we can deal with this issue. Do you see the point there? All right. The colonial masters have changed. We are trying to be more virtuous, or more whatever, if I may call that word, all right, than our colonial masters. The Legal Profession Act is interesting. It's evolved from the FMS enactment of 1914, followed by Ordinance 4 of 1947, with Straight Settlements Ordinance 1934. So you can see it comes straight through from London, India, straight settlements, and then it branch off to the Federated Malay States. These details I got from an excellent book on the legal profession by the late Professor Tan Yuk Lin, a very interesting book tracing the history of Malaysian legal profession and Singapore, of course. The LPA principal features also, interestingly, followed part of the Singapore 1966 Act. So in passing, we could also mention Singapore has also pragmatically, okay, I come across now because the Prime Minister of Singapore is the ultimate pragmatist, right? There was a headline yesterday I was reading and I smiled a bit. Mr. Lee Hsien Loong combined pragmatism and poetry. I said, my God, since when did Lee Hsien Loong cite poetry, all right? Then I joked with some of my friends, probably the speechwriter just snuck in a poem or two, all right? Sometimes these are all part of their marketing of who the Prime Minister is. Pragmatism of Singapore is exhibited by, they have moved on. They have also worked on this third-party litigation funding. I don't have the details. For reformers gathered in this room, I think we should look at Singapore. We should look at Hong Kong, which is what I was exposed to in that first session I had with Tan Sri Arif Yusuf chairing, Teresa Ching sharing what Hong Kong did. And I understand, looking at the program, that there's a Hong Kong presenter, so be ready to ask her some tough questions. Don't ask me the questions because I'm not a Hong Kong reformer, but the Hong Kong reform is worth looking at because they do try to seek an equilibrium between preserving, all right, the ethics of proper litigation practice by professionals with regulation and self-regulation of third-party litigation funding. So the history of our act shows how it is linked to our colonial forebears. The large issue for me, and as I highlighted in my opening remarks, is what does it mean for us to belong to a profession? We all know the word profession is a very important word. Sociologists will tell us it's supposed to distinguish itself from mere business, mere marketplace. Otherwise, if I may be very controversial, then we are no better than doing a skin trade, all right, if I may use that euphemism, okay? So where are we at in this whole idea of who the profession is? And I remember John Farrar, some of you may study in Singapore, Australia, Farrar and Company Law, right? The lovely man, and I like that statement he made in Farrar Company Law book. Company law happened to be my favorite subject too, other than my other subjects. John Farrar says, businesses are trying to be more professional, while professional has turned into business. It is a kind of a paradox, I mean, irony, right? Professions have become more and more business-like, and business are posing themselves to be a professional. But here we are. So is being a lawyer a calling, a vocation, which grants us status and respect from the public when they discharge their duties to the clients? Or is it measured by how profitable we are and the financial success and outcomes of our case? This is the struggle I have every day when we come across the admonition by our senior judges and judges in both the High Court. I move calls of young lawyers, and there's admonition to say, your profession is not meant to be a mere business. But we know how hard it is for young lawyers. I understand the last count is we're coming to 23,000 lawyers. That's a lot. When I first started, someone said to me, Philip, are you sure you only be a lawyer? There are 2,000 lawyers, in Malaysia. And I was sucky. I said, no mind, there's room somewhere in the top. All right. A bit sucky. Now you got 23,000. And I see all my associates slaving away, trying to gain some posts in my medium-sized firm. And also all of them are very good. And they're working very hard, all right, to find a place in its 23,000 lawyers, where 16 or so thousand are in Klang Valley. Imagine that competition for the business, all right, and the harshness of the environment. So funding, that is just my playful way. Litigation funding is defined very well. If you are interested, you can check out the website of Association of Litigation Funders of England and Wales. It defines litigation funding is where a third party provides the financial resources to enable a costly litigation or arbitration case to proceed. The litigant obtains all or part of financing to cover its legal costs from a private commercial litigation funder who has no direct interest in the proceedings. In return, if the case is won, the funder receives an agreed share of the proceeds of the claim. If the case is unsuccessful, the funder loses its money and nothing is owed by the litigant. Because the litigation funder's return is tied to the success of the case, funders look to fund cases with only good prospects of success. The funder shares or proceeds of a successful case is negotiated with the litigant at the outset. The financial reward typically consists of either a percentage of damages recovered or a multiple of amount advanced by the funder or a combination of the two, though these are variants of what a definition of litigation funding is. Just check out the website. You have a proper definition. I apologize if I'm much more hardworking. I will put the definition up there, but in my moving around teaching literature, I get carried away by nice quotes. So I don't become too precise like a lawyer, which I should, all right? Where am I? So this is just a mere definition OED. The longer definition I just read out is the proper one for third-party funding, all right? The traditional image of the member of a bar in English is that fees and payments are to be dealt with separate from the discharge of his work. I remember as a young man entering University of Malaya Law School, the third batch, right? Then we have this small little book called Learning the Law, right? Original one, not the one that are updated, which is full of don't know what. Glenville Williams' story still reverberate in my memory. There was a barrister who won a case, and the client said, "Mr. Barrister, thank you so much. I'm so happy I won the case. How shall I thank you?" "Madam," he points to the pocket behind his robe, "pay my fees." All right. So there we are. The issue of, but now of course barristers won't even go to court unless the clerk has collected your fees. All right. Be sure that you are no longer, even though there might still be a pocket. I don't think there's any pocket left because the pocket won't be able to carry. He will probably have a QR code and something and say, "Well, pay me now until you do pay me now. I won't walk in." All right. I mean, I heard of now beggars in the street having this touch and go pay. You want to donate, you just pay, giving him some money using the QR code. Maybe soon we will be reduced to doing that before we walk to court and say, "Madam, please pay me before I walk in. Otherwise, you're on your own." All right. Anyway, that's my parody of what's going on. So we are a legacy of the late Victorian bar. And C.S. Lewis, one of the good writers, say he wore the expression of a 19th century gentleman with something in the fun. At the end of the day, it's not the F-U-N. There's no fun in litigation. There's only the fun that we're looking at. We can share the proceeds. I was looking at a very interesting old book by Raymond J. Cox about the Victorian bar, and I found this quote fascinating. The ethos of collegiality and camaraderie shared by elitist profession, where cases are conducted with dignity and honor, are faced with increasing pressures from the dynamics of a marketplace and to maintain a sustainable legal practice. I would also say the compelling case as the bar grows from 23,000 to 50,000. How are we going to have a sustainable bar? How are we going to give that phrase, which will be dealt with in subsequent sessions in these 2 days, access to justice, all right, for those who are unable to fund an expensive litigation, though they have a legitimate claim. Of course, one will immediately ask, how do we distinguish legitimate or not so legitimate claims? These are part of the self-regulatory code, which another session will deal with. The principle of self-regulation and promotion of public interest has led to the fashioning of rules, all right, that govern our LPA. The LPA sets these issues out, and they're legislative and quasi-legislative in nature, all right? Look at the legal profession practice etiquette rules. I know many of us, when we go to call to the bar, you have some course and you tick the boxes. After that, we try to forget about it. But it's part of what governs us as the legal profession. And there are subsidiary legislation, my argument, under Section 77 of the LPA. It is not just mere guidelines and rules. They are a subsidiary legislation. Part 6 dealt with remuneration of advocates and solicitors. No advocate shall purchase interests of client and provide except as expressly provided in written law or rules made under this act. No advocate shall purchase or agree to purchase directly or indirectly an interest or any part of the interest which is subject of his client or that other party in the same suit. Enter into an agreement which is retained to prosecute a suit which stipulates for contemplated contingency fee arrangement. There's another one I did not quote in my slide. No advocate and solicitor shall share fee with a non-practicing advocate and solicitor, right? We are aware that these are the prohibitions in the LPA, in the remuneration section of the LPA, a very critical part of law that needs to be amended, all right, in a manner that will permit third-party funding. Without that amendment, we can talk, and technically we may be contravening this provision. Section 37(2)(a), any unauthorized person who does or solicit the right to do any act, this is touting, customary within the function, including and not limited to advising on law, a very wide session, right? So I see, and I'm not trying to be overcritical because I'm not that active. I'm not active at all in the Bar Council, that there could be a website trying to advise indigent women who are left bereft of family law help. They are hauled up saying that you are providing advice on family law. Now, I'm not trying to argue the merits or demerits of that agency offering the service, but to me, I thought, well, isn't it quite helpful to know that there is a website where poor women who are left bereft of maintenance could go to and get some basic legal advice, right? Isn't that an exhibition of the failure of our legal aid systems? All right. I think these are important points for us to look at, and the legal profession, and I don't want to have this self-loathing, flagellating the legal profession. All right, we cannot think that we can monopolize services. It's over. The day and age of monopoly of services is over. It's whether you can give superior ethical service with integrity, isn't it? At the end of the day, I mean, it's over. We're trying to control conveyancing practice. We're trying to control overseas practitioners. I mean, this is my favorite story, right? They are all doing Malaysian law from Singapore, Hong Kong, some fly in with their fancy Louis Vuitton bags and sit in front of you and they argue until you get angry enough and say, are you practicing law? I'm going to report you to the bar council. All right. I heard of one case like that. The poor guy quickly calmed down. All right. I mean, these are issues that the profession need to self-reflect. And I think that we have to, as I would call myself a senior member of the bar, we need to think carefully what we make prohibitory and whether the context and rationale where that prohibition held sway holds anymore, and whether we can still protect that rationale while reforming it in a manner that permits third-party litigation funding. Okay? I'm beginning to sound like a preacher, but maybe because you're here, I'm preaching to those who are already believers. All right, we need to reach out to the unbeliever. Okay, touting, of course, is different. Touting, of course, we have all this, and the cases are clear. I don't want to go into that. And recently, there was some huge case about how there was some misconduct of touting. But we know during my undergraduate days, I remember a top professor from Cardiff University, Philip Thomas. There's an article in the JMCL that talk about ambulance chaser, the barons and the lieutenants. Wow, it's quite interesting, the title. All right. The whole, and again, I'm not trying to be overcritical about people who practice in this area, right? I don't. I mean, we can be so moralistic and self-righteous. Obviously, there's abuse. I learned of a case where my friend had a bad accident. The not widow, he's not widow. She didn't want to come up with 80,000, 100,000 to fight the case. I said, do it. The case is so clear cut. She went, I won't mention a lawyer, to a contingency fee lawyer. We charged 20%. So when she got 3 million or whatever, 20% went to the person, more than that, 80,000. It was a clear case that she can win, but she didn't want to risk her capital. You follow me? But it's happening, and again, I don't want to over-condemn the lawyer that did that 20%. But if he's reported, that's against the law. That's against his contingency fee. All right. But there's only a fragment of what's happening out there. It's happening right now. All right. Don't pretend it's not happening. Right. So you can have all the anti-touting provision, but how do you enforce it? Who reports this? And if you report it, who has the energy to pursue? All right. No advocate should accept a brief if such acceptance renders it difficult to maintain its professional independence. Again, here we are. So one of those self-regulatory codes says third-party funding, make sure that they cannot intrude and interfere in the conduct of the case. All right. A very laudatory, exhortatory principle. Again, whether it will be complied with, these are issues where we all know code of ethics and regulatory codes can only go that far unless we as a professional, and I saw the word fiduciary, exercise our fiduciary duty, exercise self-discipline in regulating that way. All right. No rule can circumscribe or dictate whether we pursue a path that is virtuous or which is vice. It is true, isn't it? We all know from law and economics theory, which I have some interest, all right, the Cozen theory. I am bastardizing it, all right? Any rule anybody make, the stakeholders or regulatory will find ways to circumscribe it if they want to, all right? Like politicians, there are conventions, they're not supposed to do certain things, but they do. And then we all scramble and say, alamak, what's going on? Isn't what the federal constitution says that? And then we endlessly debate. Anyway, I don't want to move to public law. Advocate should not appear matter is directly or indirectly pecuniarily interested. I mean, wide principle. Again, this needs to be tweaked if we are to introduce the third-party funding. So the freedom of advocate to contract with any party in terms are paid is constrained. And therefore, LP need to look at. Pro bono work is exempted. Wonderful statement of Lord Killerwin. We know law is an expensive luxury and justice would not be done if there were no professional men to take up the cases of humbler classes and take the chance of ultimate payment, sometimes no payment. I would like not to bash my profession. There are so many men and women of good faith who maybe out of bad conscience because we practice law and we make enough money to buy our second car and a second house. So once in a while, we do some pro bono work. All right. I'm not saying we are all that great in our virtues. It's out of bad conscience. We do pro bono work. We do. And Malaysians lawyers have rose to the occasion. I have many. I have what few Queen's Counsel now, King's Counsel friend. You say, wow, you can do the case pro bono, all the way from High Court to Federal Court. We would never do that. Even of course, there are some exceptions when there's a causa celeb case and they want to gain the global recognition, then they will do it. Most of the time, they say, put money where your mouth is before we champion the case. All right. And that is the gravamen. But Malaysian lawyers, I want to pay tribute to many men and women of good faith who have done that. But we cannot just sustain that. In a recent interview I had in Nepal, a young undergraduate of Kathmandu Law School asked me, call me professor because I'm adjunct, right? Professor, what do you think, advice to the undergraduate who have ideals about human rights? I say, go and get a sustainable a job first, right? And become sustainable. Of course, don't give up the ideals, but it's hard. It's hard. So prohibition against champions, I think I should close soon. Have I gone beyond my 45 minutes? I think I have. So I've winged my time a bit. So I'm glad. Have you all fallen asleep? If you have, ask for forgiveness. Here we are. Prohibition against champions retainer, contingency fee and all this, and carries the risk of stirring are all part of prohibited retainers. And we have a series of cases, and I can't go into all the details. This one, again, I acknowledge Justice Su Tianju, very able research in the IMLC session. He then showed how many cases have been dealt with in different ways, different attitude. All right. We have assignment of struck down as champions. We have the fact that a champions maintainer can be tempted to inflame damages, suppress evidence, or suborn witnesses, quoting Lord Denning, or the doyen of our imaginary great judge. Of course, he's a great judge, but I'm just saying sometimes they live in an unreal world, all right, that everybody can afford barristers, all right? So where you are, Ravi JC, a very good judge, of course, accepted Denning's rationale, but he seemed to also change his mind somewhat in another case, but I won't go there, all right? And then you have James Fong, all right, who held causes of action of maintenance and championship are defunct. Is it defunct? So here you have a judge who says it's defunct. Then the other judges are saying, well, it's still very much part of the law, all right? But James Fong narrow it. They say they don't necessarily support tortious claim. They are confined to contracts. So I find that quite interesting. Here is a judge faced with something, and he decided that, well, this is a tort claim, not a contract. So perhaps we won't call it maintenance and championship. So is it a matter of accident of finding a right judge so that you classify the cause of action in a certain way? The law shouldn't be that way, isn't it? We need to be much more clearer. And these are part of the judicial cases that we need to sit down for the reform process to properly address when we amend the rules in the LPA and the remuneration provisions. So we have subject to written law, advocate may make an agreement in writing, amount and manner of payment, all right? It appears in UK, a solicitor may conduct an action on credit. So can you do that on credit and based on success? Now, these are all part of the continuum of issues, all right, that we as lawyers are navigating. In the High Court, there is cases that allow legal fees to be incurred to be recoverable as part of damages over and above the cost awarded. That is quite interesting. But I was a little bit not up to date. I quickly updated myself the last 48 hours. I found out that there's now a federal court case that put a question mark on all these cases. So please, when this panel comes up, don't rely on this. I will show you the quote in the federal court, the citation. Take a note that starting point, the retired Justice Mary Lim wrote a very interesting case that overruled Justice Su Tianju in the High Court and the Court of Appeal decision. I will show you the citation in a short while. I'm coming to my closing moment, so bear with me for a few more minutes and you shall be relieved of listening to me. The Malaysian courts in the past, all right, have permitted the claim of legal fees as damages All right, that include very interesting cases, including a very able judge, now retired, Lisa Chan, then just Judicial Commission. But as I say, my starting point was when I was in IMLC session and Justice Su was sharing. He posed the question, all right, that since costs are incurred for medical care, forensic accounting, experts report, should legal fees be any different? All right, he posed the question. You mean I have another 15 minutes, is it? Oh, gosh, I thought I'm already over. The torture that I'm inflicting on you are over. Okay, then I shall relax a bit more and go a bit slower. Su Tenju was inflamed when this case came before him. For 15 years, the claimants, I think two sets of couple, claimed against defendant who fraudulently frauded their property. For 15 years, they pursued the case until only the two widowers are left. The wives all died. All right. And when he came before Justice Su, he was pretty indignant. I think sometimes judges ought to have that indignant. But of course, sometimes you can overcome your reasoning process. And I'm not being overcritical about Justice Su. He then posed that very legitimate question. And he then ruled that 2 over million, right, costs can be collected as part of special damages. I'm summarizing a complex reasoning case, all right? Because he was inflamed with the behavior of the lawyers also, all right? That forestall the case, appeal upon appeal, contempt of court, you know all the tricks that we lawyers can go into when we want to make life difficult for the other claimants or their defendant. Again, I am not classifying all lawyers that way. I think most lawyers conduct ourselves with some courtesy, restraint, and respect for each other, and not. But in this case, Su Tenju then ruled. But the latest case, all right, is now cited. You could probably find it in MLJ2, but my able associate overnight got the federal court case for me. It's 2024 CLJU 819. The federal court reversed the decision that you can claim a heightened cost as special damages. I'm summarizing Mary Lim's very able decision indeed. Some of you have bid her farewell in some very nice ceremony, I understand. And Justice Mary Lim, very well regarded justice. I say this because I'm not trying to bodate her anymore because she's not a judge, so it's okay. All right. Very courteous and yet clear-minded judge. In fact, I sent her judgment on cost to, some of you may know that big fat tome by Dr. Andrew Chew on costs. I sent it to Dr. Andrew Chew. He said, what a wonderful judgment. All right. I need to revise my book. All right. Wow. So there you are. You have Mary Lim correcting it, not, of course, disturbing the fact that what the respondent did. All right. I mean, what the appellant did, in this case, the appellant, because they appeal against the costs as part of special damages, were wrongful, but that to marry the two together has problems in our law in the terms of cost special damages. I'm going to a much more specific area to show how the legal profession is training to deal with these issues, all right? Attempting to, I use the word navigate the shoals of legal etiquette rules and prohibition about remuneration and costs and all that, whilst in the right case, it should be applied. Perhaps the categorization by the lower courts in the Link case was overdone. It's corrected now by Mary Lim correctly, the principle of law. But there you are. Why do we need to deal with this? Why do we need to suffer, I use the word, vicissitudes of litigation and court decisions to deal with this painful area? Perhaps like the two couple who had no recourse, but for the fact that a law firm was willing to champion them for 15 years, all right? If the law firm was not able to, they would never won the remedy. They would have lost their property due to fraudulent practices we all know is rampant in conveyancing. This is part of and lawyers are involved in that. Sham agreements. We are aware of those things in our own dispute resolution practice, isn't it? So we have there are no complete saints and sinners in this world. All right, we all work in the continent. So we need to deal with all of that. We need to regulation. I use the word is imperative because litigation is a fact. You can wish it away. You can imagine that in a perfect world there shouldn't be, but the variants of it are causing fault lines within our legal landscape. And the tension between provision of access to justice. And I'm not just trying to romanticize it. Even in large commercial cases, it is true that a litigation now has become a commodified instrument. All right. There is a clear thing that we should recognize, an economic dimension in these cases. To pretend it is not there is what I call ostrich in the sand mentality. Kamraj quotes Bob Dylan, and we must be honest if we want to live outside the law, but can we? With the law, with all these problems? But where are we tonight? And how are we to chart the path forward? The utilitarian philosopher, always an interesting man, Bentham states, so long as the expense of seeking relief at law, this is a, Bentham, those of you who go to University College will see his effigy or a sarcophagus there, stands on its present footing, which is to say expensive, the purpose of seeking relief funding will of itself, independently of every other, afford a sufficient ground for allowing any man, which includes woman, of course now, or every man to borrow money on any terms which he can obtain. This is in defense of usury. We all know that our nation and economics financing system is besetted with the debate. And this debate will never end. All right, whether we are talking about riba, usury, third-party funding, that is part of the contestation 21st century Malaysian will face. And each of us as stakeholders need to examine from a utilitarian view what Bentham has said, perhaps bracketed by ideas of the remaining virtues of our profession. The guru of no regulation, Alan Greenspan, actually said, those who look to self-interest to protect also are in a state of shock. Of course, when we go for self-regulation, we don't mean to just leave it to be self-regulated. All right. You look at the Hong Kong model, have a look at that. There is a check also on their self-regulation. So I cannot chart the terrain of which why and how we will do the path forward, but we need to deal with this issue indeed. And I thank you for your kind attention. I apologize for inadequacy of my presentation. I do think that the time has come to set up the stakeholders, a proper body to examine this. The time has come for a body, non-profit in the beginning, I don't know who is willing to spend the time, to foster the idea of third-party funding litigation, and by you, the Attorney General's chambers and other stakeholders should give their views in both practical terms so that the process and the path forward may reach its necessary goal. Thank you very much.
Thank you, Philip, for your comprehensive presentation on the uncharted waters of regulating third-party funding practices in Malaysia. Distinguished guests, ladies and gentlemen, we are now moving to the next chapter of our workshop, dissecting the key aspects of the third-party funding practices. On that note, we would like to invite Ms. Kim Rooney, who is joining us virtually, to lead the first session entitled Eligibility, Statutory Criteria, and Fiduciary Responsibility of a Qualified Funder. Kim is a Hong Kong barrister and international arbitrator of aviation, commercial, finance, infrastructure, investment, ITC, and trade disputes. She chaired the Hong Kong Law Reform Commission's subcommittee on third party funding for arbitration, co drafting Part 10A of the Arbitration Ordinance and the Code of Conduct for third party funding for arbitration. Kim is also a member of the ICC Court of International Arbitration and was previously a partner of White and Case LLP, heading its Asian dispute resolution practice. She is also admitted as a Western Australia barrister and solicitor, and a solicitor in England and Wales. Kim is the editor of the IBA's Dispute Resolution International, co-author of ICCA's Guide to the Interpretation of the 1958 New York Convention, a handbook for judges, and an ADR contributing editor for Hong Kong Civil Procedure. Kim regularly teaches, including at the Peking University School of Law. With that, over to you, Kim.
Thank you very much. And may I thank the organizers of this workshop on third-party funding legislation in Malaysia, charting a forward. Very much for the opportunity to participate. As the MC kindly said, I will be speaking with you about the eligibility, statutory criteria, and fiduciary responsibility of a qualified funder. And so there is a PowerPoint, and I'm sure that our colleagues will show it on the screen, because what I'm going to do is in the next 25 minutes, walk through that. And may I mention there's a slide echo, so I am going to speak slowly. So go ask the slides could be on the screen, please. And while we're waiting for that, let me start. What will I be covering in this presentation? I'm going to focus on Hong Kong's law reform, the process and substance, including the definition we've used for third-party funding. And that's because we decided that it's very important that it be clear what concepts we're using when talking about third-party funding. If time, thank you so much for the slides there. Could you go to slide 2, please? Thank you. So you see there what I'm going to address. Focus on Hong Kong's law reform, 2017 to 2019, both the process and the substance. Then refer to Singapore's law reform 2017 to 2021, the substance and time commit. Outline the regulation and safeguards in the public interest in Hong Kong, and if time permits, go to Singapore's approach. Outline consequences of breaches by a funder in Hong Kong, particularly, and then provide statistics as to disclosure of third-party funding in Hong Kong from February 2019, when the reforms came into effect, to April 2024. Next slide, please. Thank you. So going to the next slide. I know we just did the most learned presentation, but let me share with you what third-party funding and arbitration is in Hong Kong. And to do so, we need to go back to the doctrines of Champy and Mainton as understood in Hong Kong, a common jurisdiction. And these the concepts Champy is applied mean that third-party proceedings are prohibited from funding or profiting from contentious proceedings in which they do not have an interest recognized by law. There are three exceptions, including access to justice and a miscellaneous category that covers insolvency proceedings. Next slide, please. So why are the reforms in Hong Kong needed? Well, because of the 700-year-old common law doctrines of champity, maintenance, and still apply in Hong Kong to litigation, mediation, and any other contentious proceedings that are not brought under Hong Kong's arbitration ordinance. The consequences of breach are serious. There are civil consequences potentially and criminal consequences. Next slide, please. So what is maintenance? Maintenance is defined as the giving of assistance or encouragement to one of the parties to an action by a person who has neither an interest in the action nor any motive recognized by the law as justifying his interference. What is champity? It's a particular kind of maintenance, that is, maintaining an action in consideration of a promise to give to the maintainer a share of the subject matter or proceed if the action succeeds. And I've given you this case site there. Next slide, please. So why was Hong Kong even thinking about third-party funding for arbitration? Because it's allowed in so many places, including common law jurisdictions such as Australia, England and Wales, Canada, the US especially, and a number of states, and in a lot of jurisdictions, including China, France, Germany, Korea, Japan. And Singapore, at a similar time to Hong Kong, was considering whether to allow third-party funding for arbitration. And so in Hong Kong, in June 2017, as fully implemented in February 29, Hong Kong's law was amended to permit third-party funding for arbitration. Singapore amended the law in March 2017 and amended to expand its scope 2021. Next slide, please. Now here, I'm attempting to capture the features of the process. So the reforms to allow funding by third-party funder of arbitration, emergency administrative proceedings, mediation, including interim relief, jurisdiction restrictions, set-aside obligations, and recognition and enforcement proceedings under the arbitration ordinance were implemented in Hong Kong. I should emphasize these are proceeding under the arbitration ordinance, which is Hong Kong's arbitration law based on UNCITRAL model law. These reforms followed the review from 2013 to 2015, public consultation from 2015 to 2016, and recommendations in a final report of 2016 by a specially established subcommittee of the Hong Kong Law Reform Commission, which I chaired. The 2016 final report attached draft implementing legislation, which formed the basis for Part 10A of the Arbitration Ordinance, and I, with others, contributed to the drafting of Part 10A. The legislation bill was tabled in 2016, enacted in 2017, fully implemented in February 2019, as Part 10A of the Arbitration Ordinance. The approach taken to regulation was what we call light touch, and that was a combination of provisions in Part 10A of the Arbitration Ordinance and the Code of Practice for third-party funding of arbitration, effective February 2019. Draft was submitted in 2018, and I also had a bit of helping draft that. Next slide, please. So let's take a bit closer look at what the reforms were that Hong Kong introduced. I have mentioned several times Part 10A of the Arbitration Ordinance. That's a part of the arbitration law that provides for arbitration funding and allows arbitration funding for an arbitration and related proceedings under the arbitration ordinance by a third party, the third party funder, under a written funding agreement to a funded party in return for the third party funder receiving a financial benefit only if the arbitration is successful within the meaning of the funding agreement. So, as I'll come back, the way this has been expressed is by reference to the elements of Stamperty engagements. The Code of Conduct for third-party funding of arbitration addresses a number of key issues, including the necessity for informed consent of the funded party before they enter the funding agreement, capital equity requirements, which I'll come back to, management of conflict of interest, address the service of party funder in Hong Kong. We thought this was very important, given how many funders are not based in Hong Kong or domiciled in Hong Kong. Has to address control. The control is retained by the funded party. Confidentiality, mandatory disclosure of third-party funding to the other parties and to the tribunal. Grounds for termination of third-party funding by the funded party, as well as the funder. That funders have to have a complete enforcement procedure and limited territorial application, which I'll come back to time bit. Please, next slide, please. So why are these reforms needed? From the perspective of the Law Reform Commission and Subcommittee after this review and public consultation, we decided that Hong Kong reforms were needed to ensure Hong Kong's arbitration framework reflects best practices internationally, to maintain Hong Kong's competitiveness as an international arbitration centre, and to support access to justice. We conclude it was in the interest of arbitration users and the public to allow third-party funding that was subject to ethical and financial safeguards that funders are required to comply with. This was to protect against potential abuse. And I'll come back to those safeguards in a bit more detail shortly. Next slide, please. If you look at Part 10 of the Arbitration Ordinance, you'll see a section called Interpretation. And you'll see many terms defined in it. Now, why are so many terms defined? Because we want to provide a logically consistent, harmonious framework. There are a couple I'd like to draw your attention to. You'll see that arbitration funding is defined as this. In relation to an arbitration means money or any other financial assistance in relation to any costs of the arbitration. And you'll look at the definition of costs, and you'll see that it means in relation to an arbitration, the costs and expenses of the arbitration, including pre-arbitration costs and expenses, and fees and expenses of the arbitration body, the institution. Next slide, please. This framework covers potential third-party funding, and it also addresses what is meant by provision of third-party funding. And you'll see it's defined to be in relation to the provision of arbitration funding to a person, the recipient, to include the provision of funding to another person, for example, the recipient's legal representative at the recipient's request, and related to the provision of arbitration funding by a person, the funder. It includes the provision of funding by another person that's arranged by the funder. As has already been said, third-party funding structures are evolving, endeavoring in a way future-proof a bit. Now let's move to the next slide, please. Now, forgive me for going to the words typically of what third-party funding of arbitration means. I have mentioned already, but let's have a look. Is the provision of arbitration funding, remember that's funding the costs of an arbitration, under a funding agreement in writing, which has to be in writing, to a funded party by a third-party funder, in return for the third-party funder receiving a financial benefit only if the arbitration is successful within the meaning of the funding agreement. It is very important to have clarity as to what is the parties' agreement success is in an arbitration. Now let's go on to the next slide, please. This sets out the definition of a third-party funder. So who is a third-party funder in Hong Kong? Our definition is a little different to the one, for example, Singapore has adopted. And it's by reference again to the doctrines of champion maintenance. So our definition in Hong Kong is a third-party funder is a person who is a party to a funding agreement for the provision of arbitration funding for an arbitration to a funded party by the person, and who does not have an interest recognized by law in the arbitration other than under the funding agreement. So once again, try to keep it simple, try to keep it clear. Next slide, please. So I mentioned how the law reform and indeed the Hong Kong government thought it's very important that there be safeguards for third-party funding to protect the funded party against potential abuse and in the public interest. May I mention here, we bore in mind that our review was of the terms of the relationship between the funder and the funded party. We were not viewing the background for capital raising by the funder. That's covered by the legal framework in Hong Kong in the financial services sector. That was not our focus. So the regulatory approach adopted is by a code of practice for third-party funding of arbitration, which all funders of cases seated in Hong Kong or where work done in Hong Kong for arbitration seated outside Hong Kong or that have no seat. This applies to all funders. And the courts play an important supervisory role. And there's also an advisory body that receive reports of all disclosed funding in Hong Kong, of any complaints, and generally the operation of the system. We decided that there's no need for reform regarding security because we also considered whether or not there should be a power of the tribunal to award against third parties, including third-party funders. But whilst there were arguments in favour of that, it was recommended it not be implemented. And one of the major reasons for that is because we know arbitration is a consensual process between parties in Hong Kong by written agreement, and third-party funders are not currently parties to those kind of agreements. So I suggest that we go on to the next slide now, please. So this code of practice for third-party funding of arbitration applies to all third-party funding in Hong Kong, wherever they're located, and it's intended to protect users of the third-party, the funded party, and to be in the public interest. Yes, please go to the next slide, please. So what's sorry. Next slide, please. So the source of the power to code of practice in the arbitration ordinance, which provides that the authorised body, the advisory body I mentioned, may issue a code of practice setting out the practices and standards with which third-party funders are ordinarily expected to comply, in carrying on activities in connection with third-party funding of arbitration. Next slide, please. Now, there's a detailed provision in the arbitration ordinance that addresses what's to be covered in the code of practice. I see I've been speaking for 22 minutes, so if I may I invite you to read through this on another occasion. I'm going to summarize it in a minute, but it covers the conduct of funders from the time they start talking to a party about potentially funding them to conclusion. Next slide, please. And you'll see there's important part includes the funded party should be informed that it should obtain independent legal advice on funding agreements before entering into them. Third parties funders should provide the funded party with the name and contact details of the advisory body, requirement for minimum amount of capital of the funder, and various other matters. I'm going to come back to them in a little bit detail. Next slide, please. Now, may I mention here, the third-party funders are required to submit annual returns to the advisory body, including on complaints against them, findings by a court or tribunal, and also they give reports of arbitrations disclosed. So that means the government, the Department of Justice, has statistics for how many arbitrations are being funded in Hong Kong where disclosure has been made, and I'm going to conclude by reference to them. Next slide, please. So as I said I'm now going to quickly share with you a few of the key aspects of the code of practice, being mindful of time. I've already mentioned, we considered in Hong Kong it was essential the funded party give their informed consent to the funding agreement. So there are provisions dealing with the information to be provided to them when negotiating with the funder. The capital adequacy requirements are to be found, and I'm going to wave at you, although you may not see it. This code, I don't think you can see it, sorry. We have the code of practice for third-party funding for arbitration, and in section 2.5, it deals with capital adequacy. Now, let me just share with you quickly what are the capital adequacy requirements. Maintaining capacity to pay debts as and when they fall due. Covering the aggregate amount of liabilities of the funder for 36 months minimum. having a minimum capital adequacy of Hong Kong 20 million, which is more than US 2.5 million, and a continuous disclosure obligation as to their financial circumstances. As I say, it's set out in detail in the code. Other features of this code of conduct include managing requirements that funders manage their conflicts of interest potentially, the address for service of a third-party funder in Hong Kong, I've already mentioned that, provisions that make it clear control is retained by the funded party, confidentiality, mandatory disclosure of third-party funding, I've already mentioned, both to the other party or other parties in a case and to the arbitral institution, grounds for termination, including for the funded party as well as the funder, because we'd observed that a code of conduct in another jurisdiction that was voluntary did not provide any way, this is in 2014, any express way that a funded party could terminate, complaints and enforcement procedures, extraterritorial application, and various other. Next slide, please. I'm going to try to slow down, but I know I've now exceeded my 25 minutes. I'm going to do two more issues. On this occasion, I apologize, won't talk about Singapore, but there's an outline in the slides. One of the consequences of breach of Part 10A of the Arbitration Ordinance or of the Code of Practice for third-party funders. Now, Hong Kong, as I said, decided to adopt a light touch approach to regulation. Hence, it is said that as to a non-compliance with Code of Practice, this is in the Arbitration Ordinance, Section 98S, a failure to comply with the provision of the Code of Practice does not of itself render any person liable to any judicial or other proceedings. In other words, of itself, it doesn't give rise to an action. However, the Code of Practice is admissible in evidence in proceedings before any court or arbitral tribunal, and any compliance or failure to comply with the provision of the Code of Practice may be taken into account by any court or arbitral tribunal if it's relevant to a question being decided by the court or tribunal. So the court or the tribunal have a supervisory power, and there can be consequences if they think it's fit arising for non-compliance. Next slide, please. Thank you. The next slide. Then you'll see there's also a provision in the Arbitration Ordinance, our arbitration law, for the consequences of failing to make the disclosures that are obliged, that a funder is, or a funded party is obliged to make. Same approach as to failure to comply with the code generally. A failure to comply with this division does not of itself render any person liable to judicial or other proceedings. However, such failure to comply or compliance may be taken into account by any court or arbitral tribunal if it's relevant to a question being decided by the court or arbitral tribunal. And that might be a range of matters, including, for example, conflicts that may have arisen or claims for costs. But that's a big topic in ourselves, and we'll come back to it now. I've been talking for 28 minutes. So can I ask the colleague kindly working these slides to go through to slide 29, which are the statistics. Thank you. To slide 29, please. I thought it might be helpful if we could share with you what the Hong Kong statistics are for third-party funding, because as I mentioned, there is mandatory reporting in Hong Kong to the advisory body of arbitrated of cases which receive arbitration funding. So as I mentioned, the arbitration funding regime came into effect in February 2019. The Department of Justice in Hong Kong, for the purposes of this workshop, kindly gave me the updated figures from February 2019 to 30 April 2024. There has been disclosure of third-party funding in 89 cases. To put that in context, and my understanding is nearly all those cases are Hong Kong International Arbitration Centre cases. So by reference to the HKIC statistics available as of the end of 2023, approximately 5.5% cases between 2019 and 2023, 5.5% have disclosed third-party funding. And the other statistic I got there is to do with outcome-related fee structures reforms introduced in Hong Kong in December 2022. That's contingency fees, success fees for lawyers. So far, in the 16 or 17 months, there have only been 6 cases. So the reason, ladies and gentlemen, I wanted to share those statistics was so you could see that even though Hong Kong has third-party funding, even though it's being used, it's only being used to date in about 5.5% of the cases. Now, I've come, next slide, please. Let's finish with the next slide. When thinking about what were key issues we considered during the reform process in Hong Kong, they included what is a funding agreement? Who is a third-party funder? Should there be disclosure, and if so, who, about third-party funding? What should be the approach to regulation? What duties should be imposed? What protections and safeguards for parties should there be? Should this apply to third-party funders, whether they're in Hong Kong or registered in Hong Kong or not? What are the consequences of non-compliance? And then, of course, a range of others. But thank you. I have now spoken for about 31 minutes. I thank you very much. And if I understand there'll now be a discussion Q&A session, but thank you. May I mention, I can't see the auditorium at the moment, but I guess you're just putting that in place. Thank you. Thank you. I can see now the stage. So I guess there's going to be a moderator, right?
Good morning, Kim. Thank you so much for the presentation. My name is Vishnu. I'm a case counsel at the AIAC. Just had a small doubt with respect to the ordinance. So if I understand correctly, the administration in Hong Kong had they took a conscious decision that the champati and the tort of maintenance would continue to be an offense. And therefore, the ordinance in section in part 10A carves out an exception in, I believe, if I'm not wrong, it's section 98K and 98L, which deals with this exception. You know, so the act of champati and the tort of maintenance would not apply to arbitration proceedings. Now, I just wanted to understand if you think about the doctrine of repugnancy and how it would apply. So the criminal ordinance specifically states that these two, the champati and both the tort of maintenance would continue to be an offense punishable for, I believe, 7 years, whereas the ordinance carves out such an exception. So the legality of such.
Sorry, yes, I lost you. You froze for a minute. Can you still see me? May I mention I've lost you? I'm going to log back in. Hello, I'm back. Can you hear me? Hello, can you hear me? Hi, can you hear me okay, Fakrul?
Yes, yes, Kim. I can hear you. Just a moment because we're connecting the audio to the auditorium. Just give us like a 1 minute.
Yeah, sure. I just want to make sure it wasn't me. It's okay.
No. Okay, thanks.
Apologies for that. We're just sorting out some audio issues. Please bear with us. Thank you.
Thank you. No, I'm glad it's not me. That's good. Thank you.
Kim, I don't know if you heard my question before, but I just repeat it because we couldn't
Thank
hear your
you.
answer to it. Yes. Thank you once again for the presentation. Um, the question was with respect to how the ordinance deals with the tort of maintenance and champati. There's a specific exception carved out in Part 10A. I believe it's section 98K and 98L. I'm not too sure about that.
Yes, that's yep.
So I just want to understand, if you think about the doctrine of repugnancy, you can't have two statutes which say opposite things, or which contradict each other. So when you have the criminal ordinance in Hong Kong, which states that the act of champati and the tort of maintenance continues to be an offence, what is the legality of having such an exception in the arbitration ordinance?
Thank you for this very hard question. When from memory, the criminal provisions and the miscellaneous offences ordinance is in there. When we looked at it, we working with colleagues from the Department of Justice in the Law Reform Commission, and also did our own research. From our perspective, the concept of repugnancy was not raised, but what we looked at was that with the doctrines of champati and maintenance under common law, concepts evolved by the courts, as you know, although as you point out, there's a criminal statute that affects it. There are exceptions already, and it was considered that we could address the, and as you say, expressed to be the common law offences of maintenance, including the common law offences of champati and common marriage, do not apply. That's simple. And in Hong Kong, it was considered that would work. But now you've raised this question, I'm going to go away and discuss it with my colleagues. But from the perspective of the Law Reform Commission too, we have sitting on that the most senior judges, Court of Final Appeal, as well as other judges, and it was thought this could work. But I'm sorry to give you a learned response, and I'm going to think about it and talk to my colleagues.
Thank you, Kim.
Do we have any other questions from the floor? Okay. With that, thank you so much, Kim, for the insightful session. And despite the technical issues, thank you so much for being here with us today virtually.
Thank you, and giving me the chance to share our experience with you. Thank you very much.
Thank you. We look forward to hosting you physically at the AIAC at our future events.
Thank you. I can't wait. And I'm going to do that next month for something else, but thank you. Goodbye, everyone. Thank you very much.
Without further ado, let us now move to the second session of our workshop entitled Cultivating Funders' Professional Responsibility, the Importance of Code of Ethics and Guideline on the Best Practices. For this, joining us from Milan is Professor Catherine Rogers, the speaker for this session. Catherine Rogers is a professor of law at Bocconi University in Milan, Italy. She has lectured and taught around the world, including at several US law schools, Queen Mary, University of London, and the International Dispute Settlement Program in Geneva. Her scholarship focuses on the convergence of the public and private in international adjudication, the intersection of markets and regulation in guiding professional conduct, and on the reconceptualization of the attorney as a global actor. Professor Rogers is a reporter for the American Law Institute's restatement of the US law of international commercial and investor state arbitration, and she's also a co-chair of the ICCA Queen Mary Task Force on Third-Party Funding in International Arbitration. She is the founder and CEO of Arbitrator Intelligence, which promotes transparency, accountability, and diversity in arbitrator appointments. Professor Rogers is also regularly involved in capacity building projects and trainings around the world. Apologies, ladies and gentlemen, we're having some technical issues, and Professor Rogers will be joining us in 5 minutes' time. Thank you. ladies and gentlemen. Apologies for the slight hiccup just now. Joining us from Milan is Professor Rogers. She's here with us now. Hi, Professor Rogers, can you hear me?
Still drinking a little coffee because it's late.
Yes. Over to you, Professor Rogers.
Okay. Good morning. I'm not sure. Okay. There's an echo. I'm hearing very strongly. And I'm not sure how to turn it off. Okay, now it seems like it's resolved. So thank you so much for having me. Good morning to everyone in Malaysia. Good afternoon, good evening to everyone anywhere else. I'm especially happy to be here today because it seems to me a really great thing that Malaysia, and particularly the AICA Arbitration Center, is taking up these very important issues of third-party funding. Two of its neighbors, its closest neighbors, Singapore and a little further away, Hong Kong, very directly took up the issues of third-party funding and international arbitration several years ago in 2017. And while we think, okay, neighbors pass legislation all the time, it happens to be coincidental, this legislation was incredibly important because both of how in both jurisdictions, it was done incredibly carefully and thoughtfully. They're really, I think, both, even if they have some differences between them, excellent examples of just really thoughtful legislation, number one. Number two, they came at what I consider a really watershed moment in international arbitration. So today's talk, I'm going to give a somewhat personalized view of how third-party funding has evolved in international arbitration and some of the ethical issues that are implicated. And I will address a range of ethical issues from not only regarding arbitrators and conflicts of interest, which was the starting point for concerns about requirements for disclosure, but more generally, including other actors, counsel most particularly, and also the role of the regulator, the state, because I know that the government of Malaysia is in fact one of the co-sponsors of this program, which leads me to assume that they might also be considering some type of legislation. So I said a moment ago that the Singapore and Hong Kong legislation was at a watershed moment. I'm going to take you back to, let's say, 2015, 2014, 2013, when third-party funding was first emerging as a phenomenon in international arbitration. We were learning that there was this new thing that somehow was being used to finance claims in international arbitration. And it was oftentimes, and I'm sure you've already had a definition in this program, but the programs back then in 2013, 14, the discussions on listservs, the client updates, the news about third-party funding mostly focused on the question, what is this? Because it was new. And it was a phenomenon people were unfamiliar with, even if it has existed for a very long time. In some jurisdictions thriving, like for example, in Australia, and a little bit more behind the scenes in some other jurisdictions. So mostly we talked back then about what is third-party funding. At that time, it was also the case, I think, that partially because it was new, because it was misunderstood or not understood, there was a deep apprehension. And I have to say, I think it was pretty universal. Even Forbes magazine, back maybe even a little bit before then, and with regard to litigation, not international arbitration, really had said there was kind of what they called an ick factor, like icky. It's kind of icky. Why the concern was, when it was new, that third-party funding somehow commodified justice. It was people trying to make a profit off of justice. And those two seemed deeply incompatible, at least at a sort of visceral level. Now, for those of you who know my work, you know my focus is on ethics and professional conduct. And so some people sometimes are a little surprised with this view I have, which is I'm not as much concerned, or I think to some extent that view that it's icky or that it's a commodification of justice is a little bit in tension with the idea that, in fact, actually pretty much all the actors, especially in international arbitration, which is private, are making money off of justice. So lawyers, except those who do it pro bono, and there are very few cases of which, lawyers represent clients to make money. Arbitration centers, sometimes designated as nonprofit, sometimes not, but they are fighting for market share to make money. Expert witnesses, arbitrators, okay, who are the adjudicators. Yes, I think they love their jobs. I think many of them feel a higher calling, but they might not be willing to do it, or not nearly as much, if they were not making money. So I put that aside because I think that this is really serious business. It's serious work, and it raises serious regulatory questions that can't be, in a sense, viscerally dismissed. That they're somehow other, they're somehow icky, and so the only point of regulating them is to control or eliminate or limit them. Third-party funders are by now an integral part of international arbitration. And so when both Singapore and Hong Kong passed their legislation, they did two things. On the first hand, they completely they took away legal barriers that prohibited the use of third-party funding for international arbitrations seated in Singapore and Hong Kong. So that's the first thing they did. They effectively legalized third-party funding. The second thing they did is that they also then regulated it. I think they're both instances, even if maybe due for an update at some point soon, they were instances of regulation that was strategic. They did not, in a sense, react viscerally to concerns about the sort of commodification. Instead, they said, okay, we've now legalized this. It's going to be part of arbitrations here in Singapore or Hong Kong. We need to make it worthwhile. So they did put in requirements for disclosure of the presence or participation of third-party funder in a particular dispute, and the identity of the third-party funder. And that's where we'll start. So why require the disclosure of the identity of the third-party funder? The number one reason why the disclosure was called for in the beginning is because arbitrators may, the idea was, have a potential conflict of interest with a third-party funder. And therefore, they would have to know that the third-party funder was present in the dispute to be able to identify, to do the research, according to their duty to investigate, and determine whether there was anything that needed to be disclosed for the parties and the institution to evaluate whether a conflict of interest existed. First, for the arbitrator to decide whether they have to disclose and confirm that they can be independent. And then if there were facts that were relevant in disclosure, for the parties and the institution to decide. Now, I'm going to again take us back to that era in the 2013, because there were a couple of funders that were extremely vocal, and what I might even say bombastic, at least in one case. And this one particular funder used to start all of his presentations whenever he would, because I remember that everyone was like, what is funding? So lots of presentations, lots of events trying to educate our community that what is third-party funding. And he used to start all his talks with, there has never been an arbitral award that has been refused recognition or enforcement because of a conflict of interest the arbitrator had with the funder. That was his stock line. He also, I think, was quite intimidating for people. Arbitral institutions up and down, quite frankly, I think did not have the courage to require in their rules disclosure of third-party funding. Why? Well, this goes back to what I said earlier. Arbitral institutions, it's not that they're making huge profits from from international arbitration, but they're certainly in a competitive market. And they certainly work very hard to both provide excellent service to the parties who use them, but also to attract future parties and to increase their caseload. And institutions, particularly in light of some of the comments by third-party funders, were very concerned that they would lose business. Why? Because if a party wanted to bring a claim and their agreement had the institution's, a particular institution's name in it, and they did not have the money to bring that claim, and they were searching for third-party funding to enable the claim, a third-party funder, the thought was, would not choose to fund an arbitration at an institution that required disclosure. Okay, it was considered, if they did pass a requirement for disclosure, a competitive disadvantage to require it, which I think today seems a little, if not ironic, a little bit peculiar, because we've moved a lot since then. But there was certainly a sense that that an institution would be negatively impacted by having a rule requiring disclosure. And that takes us back once again to Singapore and Hong Kong, which, as I said, passed their legislation at a really pivotal moment. Why? Because some of the same inspiration was why they decided to remove the prohibitions against third-party funding. They decided, well, if a party who has a claim that they might want to bring cannot get funding because it's seated in Singapore, where funding is illegal, or seated in Hong Kong, where funding is illegal, all the work that we as jurisdictions and all the work that our arbitral institutions have been doing to attract more international arbitration business will be undermined. Why? Because whatever cases are funded will not, in a sense, be based in Singapore and Hong Kong, will lose essentially the business of any funded cases. And so that's why they did a two-step, one, removing the prohibition, okay? But what they also did, and I think it was a tremendous benefit for the institutions there, is when they passed the legislation removing the prohibition, they also, in that legislation, required the disclosure of the identity of the third-party funder. And because it was legally required under the law of Singapore and under the law of Hong Kong, that disclosure of the identity of the third-party funder be made, it was then easy. It was required. It was a no-brainer for the Hong Kong International Arbitration Center and the Singapore International Arbitration Center to then, in their rules, do what other institutions at the time, and I'm not denigrating other institutions, I think they were acting very rationally at the time, but now Singapore and Hong Kong institutions had a sort of legal excuse, they had a legal mandate to amend their rules to require disclosure. And I think that for that reason, they were the first institutions in the world, not only to essentially require that disclosure of a third-party funder be made in an arbitration, but they also, I think, have the best record in terms of compliance. So a number of other institutions, for example, the International Chamber of Commerce, again, for the reasons I have to say, assuming these reasons, they're not publicly stated anywhere. And it's not, as I said earlier, to diminish the importance, I think the strategic importance of the decision to not mandate disclosure if you are not legally required to, because third-party funders were, in some instances, going around saying explicitly that they'd lose business if they did this. So the institutions they recognized there was this potential, and we'll talk more about what those conflicts are in a moment, but they realized there was potential for conflicts of interest between arbitrators and third-party funders, but they also did not want to alienate or lose the potential business, okay, that might come for being seen as more third-party funder friendly. And so, for example, the ICC created a practice note, which is sort of good advice about best practices, but it is not mandatory. And in that practice note, they said it's advisable for arbitrators to consider whether they might have a conflict of interest, and they have the power, confirmed that they have the power to require disclosure of the presence, the participation, and the identity of a third-party funder. Today, the most important other, I would say, institution to mandate disclosure was, of course, ICSID in its rule revisions. And I don't remember exactly the year that they took effect, but certainly well after. They were in the works, I would say, since 2013, 14. They spent a long time on the revisions. I think they didn't come into effect until much later. I don't remember the exact year, but that was the third institution to essentially mandate disclosure. And as you know, I think we all know that third-party funding in investment arbitration raises a host of distinctive issues that aren't necessarily implicated in commercial arbitration. And I think you'll probably have someone else in this seminar talk about issues about security for costs, particularly when there are states. And that might require, for example, or states have requested, and sometimes it has been granted, that certain provisions of the funding agreement might also be disclosed. Security for costs is a little different of a focus. It's not so much on the ethics, but on questions of ability of states or responding parties to recover the costs if they prevail in the ultimate underlying dispute. But let me come back now to conflicts of interest. So as I said in the beginning, when this story was first unfolding, there was a debate. I think many arbitrators, many observers like myself, who focuses on ethics, said, yes, there is definitely a potential for a conflict of interest between a third-party funder and an arbitrator. It seems obvious. Just as there can be a conflict of interest between a third-party funder and a party, for example, if the party repeatedly appoints the same arbitrator more than a certain number of times in a certain time period, okay, under the IBA guidelines, it is 3 times in 2 years, I believe. Okay, if the party keeps reappointing the same arbitrator, the concern is that should be disclosed, because maybe it suggests the party and the arbitrator have too tight of a relationship. The party presumably keeps appointing the same arbitrator because they think they're ruling in a way that's favorable for them. If a party can have that conflict, and I think there is some debate among third-party funders, if the third-party funder is involved in the selection of the arbitrator, certainly that seems to be a very close analogy. Some third-party funders argue, well, we don't appoint the arbitrator, so we can't have that same conflict as a party. I think my view is that argument is a little too narrow to really capture what's going on. Some parties actually don't technically appoint their arbitrator, in the sense their law firm does all the research, their lawyer suggests a particular arbitrator, the party has no idea who the person is, has no idea what the qualifications that are needed to be an arbitrator in a particular case. And so they defer completely to their law firm or to their lawyer. In that case, the party hasn't technically chosen, right, the arbitrator, but we don't say, well, if they don't technically choose the arbitrator, then the rules about conflicts of interest with repeat appointments don't apply. Okay, so the same reasoning, I think, applies to third-party funders, whether they do or do not become involved in the actual appointment. They are, in a sense, a beneficiary, a third-party beneficiary, but oftentimes with quite a bit of money at stake, they're a beneficiary of an arbitrator selection. In addition, third-party funders will often tell you, and I think not only rationally and reasonably, but quite frankly, for their business model, essentially, they consider who the arbitrators are when they are deciding whether to fund a case. So sometimes third-party funders come into a case after the tribunal's already been established. Or, for example, if there is it might be the institution that appoints, and they come in after an institution appoints. It's not even their party who's appointed. Nevertheless, by choosing whether to fund that case or not, somehow the third-party funder is tying, in a sense, its fate to the identity of an arbitrator. And again, to me, it means you can't really, that doesn't obviate the question, okay, about whether there's a potential conflict with respect to repeat appointments. Another argument for why I think it's obvious that there is the potential for arbitrators and third-party funders to have a conflict of interest is that we have similar rules for the law firm. So we don't just say if the party appoints an arbitrator several times in a short period of time, several cases in a short period of time, that there's a conflict of interest. There's a similar analogous rule for law firms. Even if they have different clients in the cases, if the law firm keeps appointing the same arbitrator, many times the concern is there might be too strong a connection between the arbitrator and the law firm. So once again, whether we analogize a third-party funder to the law firm or to the party, either way, it seems that at a minimum, with regard to potential multiple appointments, there is a potential conflict of interest between third-party funders and arbitrators, meaning that the presence and identity of a third-party funder needs to be disclosed. Now, there are some other bases for potential conflicts of interest between third-party funders and arbitrators. Again, let's flash back to 2012, 2013, 2014. At that time, when third-party funders came in and were, in a sense, you can almost picture them flashing wads of money. We're going to have a big impact on this field, in this practice area. Everyone, and I think, again, we're all sort of commercial. I'm a professor, so I say we a little bit figuratively, but everyone in the field, from the institutions to the council, to the parties, to the arbitrators, to the stenographers, the service providers, the experts, they're all, in a sense, checking out, thinking about, how the new presence of third-party funders will affect their prospects for success, including financial success, in international arbitration. And in fact, the third-party funders were trying to understand the international arbitration market. And one of the ways they did that was by hiring, in some instances, even on their boards of directors, well-known arbitrators to sit on the board of directors. Now you might think, well, if an arbitrator is on a board of directors, they must know that they're on this board of directors of a particular third-party funder, so they will recuse themselves, or they'll just disclose or disqualify themselves if a third-party funder comes up in a case they're sitting as an arbitrator. Well, there's where the conundrum is. If third-party funding is not disclosed, how can the arbitrator know to disqualify themselves, right? Because they don't, they could be on the board of directors, but they don't necessarily know every single case that the funder is funding. So it could very well be that they're, as an arbitrator on a case, that the funder on which they're on the board of directors ends up being a funder on that case, including, whether they're a chairperson or even the opposing party, right? But somehow on that case, such that it would be highly improper for that arbitrator to serve. But the arbitrator has no idea that this funding is happening. Why? Back then, because third-party funding was not disclosed and the identity of a third-party funder was not known to that arbitrator. Now, herein is where I think the easy solution comes, which is, I believe, very much that arbitrators have a duty to investigate. They have a duty to inquire, make necessary inquiries about whether they have a potential conflict of interest. And normally when we think of that duty to investigate, we think of it as a duty to, research past cases, to make sure they don't own any stock of any of the parties, that they haven't, while as counsel, represented or been affiliated with either of the parties, or to affiliate it with one of the law firms. Okay. But the duty to investigate, it seems to me, always has been, even before there was any regulation, the short circuit to this idea that there is no obligation to disclose the identity and participation of a third-party funder. An arbitrator who has no idea whether there's funding in a case, it seems to me, has an obligation to ask, is there funding in the case? And if the answer is yes, to ask, what is the identity of that funder? In that way, the arbitrator can be sure, okay, that there are no conflicts of interest. Now, I'm not going to go into, there can be a number of variations of responses to that. Well, wait a minute, if the arbitrator doesn't know that they sat in 3 other cases that year that were funded by the same funder, and they ask now, how they didn't know about the others, so how does that make a difference? I think the main reason why it's so important for arbitrators to systematically include this inquiry as part of their duty to investigate is precisely because if some arbitrators feel the pressure to make this inquiry and to do it systematically, whereas others do not, we have a distortion in the market, sort of like when institutions were sort of saying, well, I'm not going to require parties to make this disclosure, so I don't want to lose business. If arbitrators, even in ad hoc arbitrations or in jurisdictions where it's not mandated, or under rules where it's not mandated that third-party funding be disclosed, if they systematically make this inquiry, I believe, 1, they are fulfilling their duty to investigate. And number 2, it eliminates the issue. It's no longer an issue. If we all sort of know, and it's clear that you have to disclose this, and the arbitrators case by case make that disclosure required as part of their existing duties of investigation and disclosure, it becomes a non-issue. And this is a point actually where third-party funders, most third-party funders at least, will agree. If they know what the rule is and the rule is clear, they can make strategic, informed decisions. If the rules are unclear or they're uneven, it's actually much harder and worse for third-party funders for their just for their business model. So I think one of the things that has always been true is that arbitrators should be making this inquiry and should therefore be making necessary disclosures. But 1, not all arbitrators know that. 2, I think it does require some courage, right? Arbitrators, when they're deciding how much to investigate and whether to disclose, have what I call a conflict within a conflict. They have duties to disclose, but they're subject to some interpretation. And if the more disclosure they make, the more they risk being knocked out, not getting appointed. And of course, every arbitrator wants an appointment that for which they receive an inquiry. And so there's a tension. I mean, I assume most arbitrators want to do the right thing, but if the rules are unclear, if it seems unnecessary, if the institution doesn't require it, then you're asking arbitrators in a moment in which they're trying to get an appointment to essentially act against their own interest to make a disclosure that's not necessarily required. And some people wouldn't even criticize them for not making. So while I think it's always been the case that arbitrators should make this inquiry and should make this disclosure, It is certainly not the case that they do. And I don't think it's right or fair to leave it on the shoulders of the arbitrators in that delicate moment. So for that reason, to the extent that the government of Malaysia is thinking about I'm going to call it normalizing, legalizing third-party funding, I would strongly suggest that the Singapore and Hong Kong models are a good one to follow, because if legislation not only removes the prohibition, but also mandates disclosure, it'll make it easy for the AIAC to then also require in its rules that all arbitrators make these disclosures. I'm going to give just a few examples. I think I've been taking a lot of your time. I'll give just one more example of a case, and then I'll open for questions that you may have. Of a case, remember I told you there was a funder who used to say, oh, there's no such thing as a conflict of interest. There's never been an award where that's been successfully challenged because of a conflict of interest. Well, my response to that, even at the time, was, well, first of all, we don't write ethics rules for arbitrators once a case has been adjudicated to have been a conflict of interest. That's not how ethics rules are written. They're written more generally. They're written to preclude that case from ever happening, not to react to it once it does, number one. But number two, he stopped actually making that statement because of a somewhat embarrassing situation that came up with his third-party funder funding a case. So I would think in other parts of this seminar, I hope you'll learn more about the definition of third-party funding. And this is a place where I think it's evolved considerably since the Singapore and Hong Kong legislation was passed. So before you can legislate against something, right, a phenomenon, an entity, you have to be able to define it. And one of the challenges with third-party funding is that we talk about it as a kind of uniform entity or a phenomenon. In fact, it varies considerably. I mean, there's the traditional model of third-party funding, where it operates like a non-recourse loan. The funder says, I'll pay your lawyer's fees, and if you win, you get a percentage. If you lose, you don't have to pay us anything. But that's one of many, many, many types. So let me give you a quick overview of a couple types, and then I'll tell you one that has specific concerns or raises specific issues for arbitrator conflicts of interest issues. So now many, depends on the funder, many third-party funders create what's called special purpose vehicles, okay? Which means it's a specific corporate entity created to fund a particular case. So it's not, in a sense, the parent funder that's funding the case, it's a subsidiary. And a special purpose vehicle created for the purpose of funding a case creates a particular challenge, right? So if we talked about repeat appointments being one of the touchstones for why we would regulate and require disclosure, a special purpose vehicle created for one case, by definition, does not reappoint arbitrators, right? So a definition of funding in the legislation needs to take account, and it's tricky. I don't want to kind of say it simple once you know it exists. It's tricky. How do you regulate essentially the parent company, okay, of a special purpose vehicle? Number one. Number two, and part of the reason that raises issues is because also in the definition you might have insurance. In many ways, certain types of insurance more than others, but in a technical definition of third-party funding, where you have a non-party that is paying for the representation of one of the parties, in many instances, an insurance company fits that definition. Do you include required disclosure of insurance? Do you not? If so, what happens when you have a reinsurance of that same case with parent companies? It gets quite complicated. But one other type of third-party funding I'm going to mention to you, because I think it was involved in the case, that the one real case we have reported where there was a genuine conflict of interest that we know about with a third-party funder and an arbitrator, is a type of funding called portfolio funding. Now, this creates regulatory challenges, and it also creates some definitional challenges in prohibitions against conflicts of interest. So portfolio funding, and it can only exist, or I think it can only exist, it's most likely to exist in jurisdictions where contingency fees are allowed. I'm actually a big proponent of contingency fees because I believe in the United States, particularly with regard to plaintiffs in mass toxic torts, in products liability cases, the existence of contingency fees has led to some very important, also, I should say, in civil rights, to some very important judicial developments that have had huge societal impacts in the United States. So I recognize they can have perverse effects, they can be problematic, but I also really believe that they've done a lot of good by enabling parties who don't have access to justice to access it. But so I think portfolio funding mostly exists in places where there's contingency fees, where law firms take cases on contingency fees, which means that they are also receiving a portion of any success. There is so law firms that do that sometimes can receive what's called portfolio funding from a funder, where the funder says, we will either loan you money or we'll, it will essentially loan you money, and you will securitize that money based on cases. In a sense, they're loaning money to the law firm, so the law firm on a contingency fee basis can fund or represent on a contingency fee basis a portfolio of cases, several cases. Okay, so in that instance, the funding does not go to the party. The funding goes to the law firm, and the law firm uses that money to essentially fund cases through contingency fee arrangements. In the one case where there was a publicly known conflict of interest, the funder had provided portfolio funding to the law firm, significant portfolio funding to the law firm. A partner at that law firm was appointed on behalf of a respondent that was on behalf of a claimant that was being funded by the same funder that was providing the portfolio funding for the law firm. Now you might think, oh my gosh, that's awful. How did this arbitrator do it? I don't know all the details, obviously, but the most obvious probable defense for the arbitrator is he didn't know. Why? Because it wasn't disclosed. He didn't know that the claimant in a case where he'd been appointed as an arbitrator was funded by the same funder that was essentially paying his, partner dividends. A big, very problematic, a conflict of interest. What ended up happening in that case, that case never went to award, because it ended up being consolidated with another case and whatnot. So the arbitrator was removed, and in fact, he's passed away now. So we never saw a court case evaluating that conflict of interest. But in my opinion, that would have been very much a very good case. Again, I don't know all the details. We all don't know all the details, but certainly it raises all the flags that would be likely to result in the first award that was annulled because of a conflict of interest between a third-party funder and an arbitrator. I want to emphasize in that case, the only entity that knew about the conflict of interest was the third-party funder. The law firm didn't know, right? Because it's a totally different claimant that the funder is funding. It's not one of the parties at the law firm or one of the clients of the law firm. The arbitrator didn't know, again, because it wasn't disclosed that the funder was funding that claimant. Okay, the claimant that's being funded by the third-party funder doesn't know that the funder is giving portfolio funding to the law firm. So the only entity that knew was the third-party funder. And it's not an indictment of the entire industry. I think the funding industry has a number of internal regulations. Most responsible funders have internal rules that they follow. The contracts with parties have certain rules as well, but they are certainly not foolproof, as I think that case illustrates. And it should not be that the funders are the only ones who know, and we're counting on their internal processes to ensure that these kind of situations don't arise. So in short, I think that to the extent that the government of Malaysia is considering enacting regulation, I wish you all the best in that it's a very big challenge. It's complex and nuanced. The good news is you have some really excellent neighbors who struggled with some of the hard questions. I think coming later, if you are in that mindset, coming later with regulation, you can stand on their shoulders because there's been some evolution and some learning since their initial regulation. I think that there are few jurisdictions, even Ireland, which was one of the holdouts that people pointed to often as prohibiting third-party funding. Even now, Ireland has shifted and now permits third-party funding, has eliminated the champerty and maintenance obstacles to third-party funding. But the bigger opportunity, I think, is not only to avoid losing cases that might not be funded because they're seated in Malaysia, but also to set an example, to also make for the AIAC the opportunity to make the easy decision to mandate disclosure, to, as you're training your excellent arbitrators there in Malaysia, to make sure that they understand their duties and to give them essentially the legislative backbone, the support in the rules to make the appropriate inquiries and rulings on third-party funding. So with that, I think we have a few minutes left. If there are any questions, I welcome them.
Do we have any questions from the floor? Yes.
Hi, Professor. How are you?
Good morning. Good afternoon.
Yeah, good afternoon. Just one short question. You were talking about the arbitrator's duty or function to inquire whether there is any third-party funding. Now, my question is, apart from inquiring whether there is one third-party funder, should the inquiry extend to also ascertaining the terms of the third-party funding as well, with particular interest to ascertain whether there are terms which are so, which might be compromising the professional independence of counsel conducting the case? Thank you.
Great question. So my view is that we didn't have time to discuss them today. I think tomorrow we might touch on them. I think you're absolutely right that third-party funding raises significant ethics issues for counsel. And in fact, some of those issues were obscured earlier, but are coming to light now. I do believe counsel have issues of independence in terms of, whenever there's a third-party not a third-party funder, a third party paying for your fees, it raises ethics issues about your loyalty to your client, your independent judgment and whatnot. Let me say the short answer to your question is, I think it is possible that might become an issue where an arbitrator has to raise it. I do not think it's a threshold matter. I think generally as a threshold matter, the contract between the party and the funder, which oftentimes can involve the law firm, right? Because they are being promised in some instances to be paid directly by the funder. And that's why I think it raises ethics issues for the counsel. Those issues I think generally do not implicate or do not require the arbitrator to act. There could be some issues where it could come up, but I think that as a threshold matter in your initial inquiry, I do not believe arbitrators have an obligation, and probably I think it could even raise problems if the arbitrators start making those kinds of inquiries. So one objection to so third-party funders have particular reasons they don't want the terms of the funding agreement to be disclosed, but I'm actually sympathetic to some of them because in some aspects of a funding agreement can raise questions of attorney-client work product, right? So when you write a funding agreement, there might be provisions in there about expert witnesses or about certain strategic decision making, and I think that those issues really shouldn't be forced to be disclosed. The types of beyond the presence and identity of a funder, the typical things that end up being requested is if there's, and only sometimes, and there's debate about it, is for security for costs. Instances where the funder, the terms might come up is, for example, there have been some instances where funders have showed up to the hearing and they have wanted to participate in the hearing, I suppose understandably, since they want to see how things are happening, their investment. And the arbitrators had to make a ruling because non-parties aren't entitled to be part of the hearing. In some types of funding agreements, the funder actually steps into the shoes of the funded party. For example, if the party assigns their claim, or in some instances, for example, a funder has purchased equity in the party that's, it's no longer a classic funding agreement, right? It's a sort of an acquisition of types. And so there might be some instances in situations like that, but I think generally speaking, that's not something the arbitrators certainly initially have to inquire about. But it does bring up a great point, which is I know in Singapore, and I can't remember necessarily, I think so in Hong Kong, I do believe that they also revised their codes of conduct for lawyers. So for Singapore lawyers, and because they had to, in a sense, address attorney obligations in light of third-party funding. Other countries have other ethics rules regarding their lawyers. And I think generally speaking, those are probably where the source of regulation should come from. Sometimes I can imagine them spilling into an international arbitration, but do they have to be a part of a threshold inquiry by the arbitrator? I do not believe so. I hope that answered your question.
Hello, good afternoon.
Good afternoon.
Thank you for the very informative presentation. Now, I got the questions. I'm an independent arbitrator. I got the questions. Will it be a good practice now for an arbitrator to do a conflict check to ask the party whether there's going to be a third-party funders? Number one. Number two, what if midway through the proceeding, they now change the third-party funder? What will happen to the position of the arbitral tribunal? Thank you.
Those are both great questions. So my view is that a good arbitrator should always ask, again, just the threshold question is there third-party funding? And if so, what is the identity of the funder? In addition, I think the arbitral rules that require disclosure usually make it an ongoing obligation. So if a party switches funders, they need to inform the tribunal and the institution of a change. Also sometimes funders come in, late in the case. So they might have no funding in the beginning when the tribunal is constituted and later acquire funding. So any rules, for example, of course, requiring disclosure should require it on an ongoing basis. If the arbitrators order it, for example, it should be in the order as an ongoing obligation that includes any changes. Really interesting question. What if a party brings on a third-party funder later in the case that creates a conflict of interest with the arbitrator? And that's a really interesting question I have not heard of, but it's reminiscent of the Hep versus Slovenia case, in which one of the parties brought on new counsel midway through, right before the evidentiary hearing, that new counsel, that new barrister, was in the same barrister's chambers as the chairman of the tribunal. And so the new barrister created a conflict of interest for the arbitrator. And the question was, does the arbitrator have to step down, or does the arbitral tribunal have the power to prohibit the new counsel, to disqualify the new counsel? And in that case, in the Hep versus Slovenia case, which was an investment case, the tribunal ruled that it did have the power to disqualify counsel. Now it's interesting because third-party funding, if you got a new funder and you can't continue the case without it, it's an interesting question. One of the issues that came up in that Hep versus Slovenia case is, can you disqualify the attorney since they're not a signatory to the arbitration? They're not a party to the arbitration. And the tribunal decided, yes, it does. Can a third-party funder be disqualified when they're, again, outside? I guess what the order would be, I suppose, would be an order that the party cannot participate using funding from a funder that's conflicted. That complexity has not come up to the best of my knowledge, but sounds plausible and possible, but not one that's been, I think, legislatively dealt with. I think the main thing every arbitrator wants to do is to avoid having an award overturned. So the more you can do to prevent that, to preclude that, by early disclosure, perhaps, for example, instead of just requiring disclosure of a new funder, maybe the order says that they have to disclose that they're seeking new funding. All right, and then the conflict check could be done before any new funding agreements put into place. But really interesting question. Let's see in the future if we can see a scenario where that actually comes up.
I believe there are no further questions from the floor. Professor Rogers, thank you so much for your time and to join us
Thank
here
you.
today virtually. We look forward to hosting you at the AIAC for our future events.
Yes, thank you all so much. And good luck to you all in facing these challenging issues. I've been to Malaysia several times, and actually to the AIAC. I have a tremendous respect for its administration and leadership, and for the government of Malaysia. So I really wish you all the best in facing these modern, very interesting, complex challenges.
Thank you.
And good luck with the rest of your seminar.
Distinguished guests, ladies and gentlemen, let us put our hands together to welcome our guests of honor, Yang Berhormat Dato Sri Azalina Othman Said, Minister in the Prime Minister's Department, Law and Institutional Reform, Yang Berbahagia Dato Amalina Sharmila binti Dato Dr. Johan, Solicitor General 1 of Malaysia, Yang Berusaha Tuan Zamri bin Misman, Director General of the Legal Affairs Division of the Prime Minister's Department, Malaysia, Yang Berbahagia Datuk Shireen N. Zahara Muhyiddin, Deputy Chairman of the AIAC Board of Directors. Ladies and gentlemen, please put your hands together again as we invite Yang Berhormat Dato Sri Azalina Othman Said, Minister in the Prime Minister's Department, Law and Institutional Reform, on stage to deliver her opening remarks.
Sorry, I have to be downstage. I heard my foot kayaking. All right, thank you so much to all for attending. To Dato, the VIPs today, Dato Tuan Zamri, the Director General for Legal Affairs Division and PM's Department, Dr. Punita, Deputy Director General, Dato Amalina, the Solicitor General from the Attorney General's Chambers, Dato Shireen, Deputy Chair of the AIAC Board of Directors, panel of speakers, representative from government, ministries and agencies, ladies and gentlemen. Assalamualaikum warahmatullahi wabarakatuh. It is a great pleasure and I welcome all of you to this special collection of great minds which come hand in hand with the government's ongoing legislative reform agenda, among others in legalizing and regulating the rapidly growing practice of third-party funding litigation in Malaysia. On behalf of the government of Malaysia, I wish to congratulate our partner, the AIAC, for their commendable effort and commitment in jointly organizing this workshop and tomorrow's KL webinar. Needless to say, today's event would not have gathered such a amount of remarkable pool of experts, practitioners from the legal fraternity and members of the public without the assistance of our supporting organizations, namely the Inns of Court Malaysia, the Malaysia Institute of Arbitrators, the Chartered Institute of Arbitrators Malaysia Branch, and the Borneo International Center for Arbitration and Mediation. In the same platform, I also like to express my gratitude to the all distinguished speakers for the unwavering support and commitment in sharing the knowledge, practical experience, and expertise with us. Ladies and gentlemen, historically, the common law doctrine of champerty and maintenance are regarded as both tort and crime to the safeguard the purity and scarcity of legal proceedings, and to a certain extent to shield parties from any potential exploitation by wealthy and powerful lords. This gradual liberalization of this common law doctrine in the last decade has naturally set an optimal ground for the growth of third-party funding practices in the legal landscape. While we acknowledge that third-party funding enables greater access to justice, it is inevitable that it opens room to undesirable control and influence by third-party funders in the legal proceedings, thereby diluting the dominance of the funded party in the gameplay. Today, as we stand at the crossroad where familiar approaches of the past no longer exist, we observe how the rapid evolution and complexity of the funding arrangements signal a stronger call for agile, effective, transparent, and above all, just regulation, specifically for this industry. Needless to say, the government of Malaysia echoes the necessity of liberalising the relic of common law doctrine and legalising third-party funding to expand the horizon to justice. This should, however, come in hand with a proper set of regulations and a standard code of ethics to maintain transparency and cultivate accountability for the responsible growth of the litigation funding industry. As I alluded earlier, this is in tandem with our legislative efforts to allow third-party funding practices in Malaysia by amending the Arbitration Act 2005, subject to certain regulatory and oversight mechanism. Speaking of this legislative reform initiative that calls for greater transparency in the litigation funding industry, if you can recall, we had curated a session during the London Colloquium 2023, specifically to discuss the concept of third-party funding, the ideal regulatory approaches while scrutinizing the unprecedented UK Supreme Court decision in the Parker case. Indeed, we have drawn valuable wisdom regarding the multiple regulatory and oversight mechanism from experts around the world as we advance our agenda towards achieving a delicate balance between access to justice and the scarcity of justice system. At this junction, given growing emergence of third-party funding practices in Malaysia, it is prudent for us to first equip ourselves with adequate understanding of the common law doctrine, litigation funding concepts and practices, and recent trends and issues which are all fundamental in aligning our third-party funding related regulations with the contemporary standard and best practices. Insofar as regulating third-party funding is concerned, today's gathering of experts and the diverse representatives from the legislative, judiciary, enforcement bodies and other stakeholders has demonstrated our resolute commitment to chart a path towards for improving access to justice in Malaysia, thereby setting boundaries against abuse of justice. I am confident that our esteemed speakers will bring us through this exciting journey to a better understanding of the third-party funding, professional responsibility and ethics, transparency and accountability, and other aspects relevant to the third-party funding. Certainly, today's workshop and the succeeding KL webinar will offer us an opportunity to look into feasible ways to streamline our regulations which best serve justice and interests of all parties. On that note, I wish all of you a very fruitful workshop and webinar. And again, thank you so much for your attendance. And I hope this workshop will bring Malaysia to a better platform when it comes to going forward in reference to the access of justice. Wassalamualaikum warahmatullahi wabarakatuh. Thank you.
Thank you, Yang Berhormat Dato Sri, for joining us today and for your kind remarks. Distinguished guests, ladies and gentlemen, we invite you to move forward to the front row for a photo session with Yang Berhormat Dato Sri. They will move to the front. Could we have the photographers on standby on the stage, please? Welcome back, distinguished guests, ladies and gentlemen. We hope you have enjoyed your lunch. We will proceed with the third session of our workshop entitled Disclosure, Conflict of Interest and Transparency Arrangement Measures in Third-Party Funding. Joining us virtually is Professor Victoria Shannon Sahani, the speaker for this session. Professor Victoria Shannon Sahani is the Associate Provost for Community and Inclusion at Boston University and a Professor of Law at Boston University School of Law. Among her many publications, she co-authored the book Third Party Funding in International Arbitration. She is the chair of the Institute for Transnational Arbitration Academic Council, a member of the International Chamber of Commerce Commission on Arbitration and ADR, and a member of the ICCA, Queen Mary Task Force on Third Party Funding in International Arbitration. Previously, she served as the Deputy Director of Arbitration and ADR in North America for the ICC International Court of Arbitration and as Deputy Director of Arbitration and ADR Committee of the United States Council for International Business. She earned both her undergraduate and law degrees from Harvard University and is a licensed attorney in New York and the District of Columbia. With that, over to you, Professor Sahani.
Thank you so much for your very kind introduction. I hope you all can hear me. Thank you for inviting me to speak with you today about disclosure, conflicts of interest, transparency measures in third-party funding arrangements. I also want to thank the organizers, the Asian International Arbitration Center, the government of Malaysia, and all the supporting organizations for shedding light on this very important topic. It is very timely, very impactful, and I'm so glad that you're addressing it here today. And thanks for inviting me to participate in this outstanding event. So with respect to third-party funding in international arbitration, as the kind introduction mentioned, I published a book on this topic, and it was called Third-Party Funding in International Arbitration, and it examined the law in more than 60 countries. And the list actually has been growing much longer since the publication of the second edition of the book in 2017. So the list is probably closer to 60 or 65 or 70 countries at this point. And one thing that I've been noticing in the research that I've been doing since then is that convergence is starting to happen. The laws don't look the same in every single country, but there is a bit of convergence. And the topic that countries are converging around happens to be disclosure. There's a lot of disparate regulations of third-party funding around the world, but one thing that most jurisdictions have in common, jurisdictions that allow for funding, is disclosure. Of course, there are also several jurisdictions that do not allow for funding, Malaysia, of course, being one of them. But in the jurisdictions where funding is allowed, disclosure is a common theme. In addition, there have been many international arbitration institutions, several of them that have adopted disclosure rules in recent years. And there's the work of the UNCITRAL Working Group 3 on investor-state dispute settlement or investor-state arbitration. And that group is also looking at third-party funding. It has a report on third-party funding and some recommendations for ways in which state parties can incorporate funding regulation or provisions into their treaties. That may include new treaties or treaties that may be renegotiated at some point in the future when the term of the treaty is up. And so there's a potential for third-party funding provisions to be adopted across the world in a wide variety of investment treaties as those treaties are either newly adopted or renegotiated. This, of course, would take a significant amount of time, but it certainly could happen. In international arbitration, when I first started this research about 15 years ago, the conversation back then was whether there should be funding in international arbitration. And people were actually pretty outraged at that time to find out that funding was already happening. At that time, it was happening sort of in secret because there was no disclosure rules. There wasn't even the idea that this was happening. So there wouldn't even have been a thought to have a disclosure rule at that time. I discovered this industry when I was working at the ICC, International Court of Arbitration. And some of the cases that were coming in were having deposits and other bills paid to the ICC by entities that were not the client and not the attorney. And that's how we discovered this industry. So here we are about 15 years later, and the conversation has completely changed. Funding is essentially here to stay in international arbitration, except in a few jurisdictions that have outlawed it, as I mentioned earlier, Ireland being another notable one. Although there is talk in Ireland that they may reform their law to allow funding. So we'll see what happens there. So anyway, the question now is, if you're going to have third-party funding, what are the safeguards that we need to have in place to ensure that funding is responsible and is constructive and is also supportive of the international arbitration dispute system? And one of the fundamental pieces of that is disclosure. Now, we can draw a line, sort of a distinction between litigation and international arbitration, because the reasons for disclosure in international arbitration are slightly different than the reasons you might want to have disclosure if you had third-party funding in litigation. So I'm going to limit my talk to international arbitration, but if anyone has questions about the issues that might come up in litigation as well, I'm happy to address those during the question and answer period. So the fundamental problem in international arbitration is something that's called the double hat problem. And you may have heard of this problem before. You might have heard it called another name. But the reason it often goes by the name double hat problem is you have an attorney or a person who serves as counsel in some cases and who may serve as arbitrator in other cases. And the issue comes up in that you might have one case in which a person is acting as counsel, and that case is funded by a particular funder, and that, let's say it's the party of the person who is acting as counsel that is funded. And you could have a second case in which the person is acting as arbitrator, and the same funder might be involved in that same case funding one of the parties. Now, of course, in that case, the person that I'm mentioning here is not the legal counsel. So they may not even be aware that the funder is funding one of the parties in the case, in the second case in my example. And yet, if one of the parties were to find out that this arbitrator had previously been working with the same funder in a case as counsel, that party in the case in which the person is serving as arbitrator might raise that as a conflict of interest, even if the arbitrator was unaware. And so this potential challenge can cause a lot of issues, one being time and cost, because you have to go through the process of adjudicating that challenge and deciding that challenge. And if it turns out that the arbitrator ends up being removed, which doesn't usually happen, but it can happen in this type of circumstance, then you'd have to appoint a new arbitrator and potentially start over, or if it's a panel of arbitrators, you may have to replace one of the three. And so this is something we don't want to happen. Alternatively, you could have a situation in which a party challenges the award at the end of the case because they lost. They didn't get the outcome they wanted. And so even though they may not have had an issue with the arbitrator having a connection with the funder during the case, once they lose the case, it gives them an opportunity to challenge the award on that basis. And so for these reasons, the double hat problem is a problem we want to avoid when there's a third-party funder potentially involved. And so the way we avoid that is disclosure by the parties to the arbitrator at the outset of the case, or at any point in the case when the funder becomes involved, because sometimes funders get involved later, doesn't necessarily have to be at the outset. So when the funder gets involved at any point, the parties would then be required to notify the funder, and that's, notify the arbitrator. And that's typically what the disclosure rules require. And what this does is enable the arbitrator to check their own records for their prior cases to make sure that whether they have any connections with that funder, any prior cases involving that funder. And so this helps us detect potential conflicts of interest before they could become an issue or be used as a litigation tactic for challenging the arbitrator later. The other issue that comes up is repeat appointments. So there may be a circumstance in which a particular funder is involved in a case or series of cases, either in the same industry or involving the same party. And in that circumstance, the funder may, and this does happen from time to time, may have either suggestions or may try to provide advice to the legal counsel regarding arbitrator appointments. Now, there's a lot of debate around the world about whether or not this is appropriate. So for the purposes of this discussion, I'm not going to address that question. It depends on the jurisdiction as to whether it's appropriate for the funder to provide that advice. But let's just say, for sake of this example, that the funder is providing advice to the legal counsel regarding arbitrator appointments. In that circumstance, you could have a situation in which a funder recommends the same arbitrator multiple times in multiple cases. And so then you have the problem of if arbitrator is appointed too many times in cases involving the same funder, you have a question about whether or not that arbitrator is truly independent and impartial. And this has come up. It actually was one of the problems a few years ago in the Vismoot. So if you know any law students that participated in the Vismoot a few years ago, they actually had this exact situation where there was an arbitrator who had repeat appointments, and there was a third-party funder in the case that had funded each of those cases. And so the students had to grapple with this question. And so this is something that can come up if you don't have disclosure, because then there could be a circumstance in which you wouldn't even know if a arbitrator was, say, impartial or otherwise had independence issues. You may not find that out until later, or you may not find it out ever. So that's another advantage for disclosure. And also sort of jointly with that, discussing conflicts of interest and why those are crucially important. So if you take these things together, this affects the legitimacy of international arbitration in the eyes of the parties, in the eyes of the court system that is looking at the award later, or in some jurisdictions, if the court is deciding the challenge, or if the co-arbitrators are deciding the challenge. These are all issues that can affect legitimacy. In addition, it can affect legitimacy with respect to the award. So I think this is one reason why disclosure is the main point of convergence so far internationally, because there's universal agreement that avoiding conflicts of interest is important. That's something that crosses legal systems, it crosses national boundaries. It's something that we as a world agree on. And so that's key. And then the last topic I want to address in the few minutes I have left is transparency measures. So disclosure is sort of the first step of transparency measures in international arbitration. Before you can ask for additional transparency, you first need to know that there's a funder involved in the case, right? So we start with disclosure. The second level of transparency, which I don't think we're there yet, but it's a possibility, is disclosing information about the funding arrangement. So it is not common, but there are a few examples out there of situations in which the rule that a arbitration institution has adopted states that the arbitrator can ask for disclosure of the funding arrangement. So it might be disclosure of a summary of the terms of the arrangement, the funding arrangement. It could be a disclosure of the actual text of the funding arrangement or specific provisions. In rare circumstances, would it be the actual entire agreement being turned over unredacted? That's very, very rare. And the only times when I've seen that is when one of the issues in the case on the merits is the funding itself, or at the cost stage potentially. If the issue is the funding itself is part of the merits conversation, or if a party has asked for cost reimbursement, a winning party has asked for cost reimbursement for the costs of funding, then the arbitrator might say, well, in order for me to consider whether to reimburse the cost of your funding, which is also rare, but let's say we have that circumstance, the arbitrator is going to say, well, I need to know how much funding you had. I need to know, what the rate of return was and what the structure of the transaction was in order to properly consider this request. So those are all very rare cases for having the entire agreement disclosed. But I have seen situations in which arbitrators have asked about how much control the funder has, whether there are provisions in the agreement that require funder approval of settlement, whether the funder might have the right to suggest counsel or even require the party to change the legal counsel if they don't like the way the case is being run, whether the funder has rights to withdraw from the case before it has concluded, so to stop funding the case in the middle. All these sorts of things can be relevant, and they tend to come up most often in investor-state arbitration. And so one of the last things I want to talk about with respect to this transparency piece and costs is security for costs. So this can come up, of course, in investor-state arbitration. Security for costs is a common request of the respondent in the case. When there's a third-party funder involved, and let's say that third-party funder is disclosed, whether by operation of an international arbitration rule or because the tribunal ordered disclosure or for some other reason, the funding arrangement is known. In that circumstance, often the respondent will ask for security for costs because they are trying to make sure that if the claimant loses the case, that they won't be left, the respondent won't be left with all these huge costs, because as we know, investor-state arbitration is very expensive. And so in that circumstance, there may be transparency with respect to whether there's a provision in the funding agreement where the funder would cover and pay for the security for costs order. And many funders that regularly operate in investor-state arbitration would pay a security for costs order. They kind of view it as a cost of doing business. It's also very common for funders who operate in jurisdictions that adopt the loser pays rule, which is the rule that says if you lose the arbitration, then the loser, as you loser, you pay the costs. So in jurisdictions in which that rule is common, the funder will often include in their agreement that they would cover security for costs, even in international commercial arbitration. So those are just some examples of some of the issues that come up. There are certainly many more, and I see my time. I reached the end of my time here for my primary talk, but I would be very pleased to continue to have a conversation with Q&A, and thank you so much for your attention.
Thank you, Professor. Do we have any questions from the floor? Yes.
Good afternoon or good morning at your location. I'm a practicing arbitrator. I got one question. You know, in arbitration or any form of litigation, that desperate litigant will take desperate measure. If during the proceeding, they found that actually they are losing the case and the sitting arbitrator is not favoring them. And if I'm a desperate litigant, I will find ways to remove him. Can I use third-party funding as a measure to get rid of the arbitrator by getting some third-party funder who I know has conflict of interest with the arbitrator?
Thank you so much for the question. I appreciate that. So I presume in your example that the case is already ongoing and you're in the middle of the case. And in your suggestion, you're saying to pull the funder in the middle of the case, because in your example, the party doesn't like how the case is going. And so they want to bring the funder in for the purpose of trying to create a conflict of interest with the arbitrator. Is that right?
Yes, that's correct.
Okay. So there would be a couple of issues with this. The first would be, depending on who the funder is, since the case is already pending, if they are a reputable funder, they're going to want to engage in due diligence on the case. So they're going to ask the party before they will agree to fund. They'll say, give us all the information you have about the case. And since this case is already pending, there's already a record in the case. So the funder would be able to know who the arbitrators are. They would know, what the basis of the claim is, et cetera, et cetera. The funder will also engage in their own analysis of how likely the claim is to win on the merits. And so in the example that you've given, the party seeking the funding is thinking that they might lose the case or thinking that the arbitrator might rule against them, right? So this will probably come out as the funder is doing their due diligence. They will be looking at the evidence and information and saying, I don't know if this case is really going to win here. And so reason number one, they might not take the case. So that might be one issue. But let's say you found a funder who saw all the due diligence and said, yes, I'm willing to take on this case. The next issue is going to be that the funder may say that they're not interested in paying for any unscrupulous litigation tactics. So they may put some restrictions on what types of things the money that they give can be used for. And so they are going to notice that if there's an arbitrator in the case that they are aware of, that they've worked with before, they're going to notice that person's name. The funder is going to say, I recognize this name. We've worked with this person in these other cases. There's a potential for conflict of interest. And they might say, we are not going to come in the case. This is a reputable funder. We're not going to come in the case unless the other party unless the other party will waive the conflict of interest with respect to the funders entering into the case, which means the funder will say, I have to be disclosed at the outset so that we can check for conflicts of interest before I'll even get involved. So that could happen. But let's say it's not that type of funder. Let's say it's a funder who's not one of the key top players in this market in the world. It's possible that someone could convince a funder to come in for this purpose. But the problem is if the funder's main goal is to earn money, then they're not really going to get anything out of it. Because if the case is a losing case, challenging the arbitrator just means you get a new arbitrator and then the case is still a losing case. So the funder is going to say, how do I make any money on a case that is likely to lose? And so I think your example is very interesting, but I think it's unlikely in the real world to happen in that way. But I do appreciate the hypothetical. Thank you.
Yeah, I note your comment, and that is what I call the conventional wisdom of the third-party vendor. But in a desperate situation, they could always get somebody who is friendly to them for the specific purpose of removing the arbitrator. Thereafter, they may just leave the whole process. I don't know whether this thing, it is possible. Will a filter system actually helps to eliminate this type of third-party funding?
Well, one thing I appreciate, thank you for the additional context. One thing that I'll add is that generally in international arbitration, challenges are very difficult to win. So even if you leave aside third-party funding for a moment, if you look at some of the case statistics from the International Chamber of Commerce, the ICC, or from some other arbitration institutions, you'll see that most challenges are unsuccessful. And this is just generally. So I think here in the international arbitration space with respect to third-party funding, you could certainly have a party try this, but I still think that unless they can show actual bias by the arbitrator, which is the point of the challenge process, is to root out bias by the arbitrator. Unless they can show that, you're going to be unsuccessful. The person will be unsuccessful in the challenge in trying to get rid of that arbitrator. That's what I think will happen. If as you mentioned, sort of the conventional wisdom, what I've observed in challenges over the years is that these types of challenges fail unless they can show actual bias on the part of the arbitrator.
Okay, thank you.
Thank you.
Any other questions from the floor?
I would like to, may I say just one more thing? As folks are thinking of their next question, I think the gentleman raised a very fascinating question, which I'll expand out a bit. Litigation or arbitration tactics, right? We have the rules, we have the general practice, But we know that there are parties out there that are trying to get the outcome that they want, and they're going to use whatever means they believe that they have at their disposal to try to get to the outcome that they want, right? And so there's always a possibility for abuse of any piece of the dispute settlement system, and third-party funding is no different. There's an argument now in the investor state arbitration context by states, and the states are saying, well, the funders are only providing funding to the claimants. They're not providing funding to the respondent. So this is an unfair system because respondent funding is not viable, or at least funders are not offering it on a regular basis. And so the states are saying, you know, they are very wary of the system of having third-party funding in investor state arbitration, especially since the funder's actual fee would end up coming from money recovered from the respondent in the end if the claimant wins the case. And so some respondents believe, state respondents and other respondents believe, that claimants will pull a funder in as a tactic to sway the arbitrator in their favor, and because many reputable funders very much vet the cases, they do their due diligence, and so they know a lot about the case. And if they're willing to invest, often that is a sign to an arbitrator that the claim is valid and that the claim has merit. And so potentially having a funder might sway an arbitrator. So there are a lot of possibilities with respect to tactics, and the situation that the gentleman raised is one example. There are certainly many others. So thank you again for the question, and I'm happy to take additional questions.
Are there any further questions from the floor? I believe there are no further questions from the floor. Professor, do you have any concluding remarks you want to add?
Sure. I'll just say that, you know, third-party funding is ever evolving and ever changing. One thing that I didn't have a chance to discuss in my remarks, but which I would definitely recommend that, you know, we think about during the course of the conference, is the definition. One of the challenges with third-party funding is whenever we try to define it from a regulatory perspective, there are types of funding that may either not be included in the definition, or there are types of financing out in the world that would be included in the definition that we wouldn't necessarily want to include. Examples might be insurance or contingency fees, depending on how it's structured. So one of the challenges with regulating third-party funding is coming up with a workable definition that is still expansive and flexible enough to ensure that as the industry grows and changes, that the regulations still remain relevant and applicable to whatever transaction structures the funders come up with. So I urge all of you in the audience to think carefully about, if you were going to try to define third-party funding in a sentence or two, how would you write that sentence or two? And what would be some of the limitations that you could foresee in trying to define the industry? Because this is something that everyone has been grappling with across the world, and we don't have a clear solution yet. So I just want to leave you with that thought, and thank you so much for having me. I really enjoyed speaking with you today.
Thank you so much, Professor Sahani, for the insightful session and for your time to be with us virtually. Especially now it's around midnight back in Boston. Thank you so much for being with us.
Thank you. Thanks for having me. Have a nice conference.
Without further ado, let us now proceed to the fourth session of the workshop entitled Funders' Liability in Arbitration Proceedings, Costs, Adverse Costs, and Security for Costs. Joining us virtually is Dr. Patricia Zivkovic, the speaker for this session. Dr. Patricia Zivkovic is a senior lecturer in law at the University of Aberdeen. She previously worked as a lawyer in Croatia, where she actively promoted the use of alternative dispute resolution mechanisms as a co-founder of the Young Croatian Arbitration Practitioners. In addition, she has extensive experience coaching students for the WIS International Commercial Arbitration Moot Court Competition, and she served as an associate editor of the Kluwer arbitration blog. Patricia is co-editor-in-chief of the Journal for Strategic Contracting and Negotiation and a published author on different topics in the field of international dispute resolution, including articles on digital transformation in cross-border dispute resolution. At the moment, Patricia is finalizing her monograph on costs in international commercial arbitration, commissioned by Alga Publishing. She is a published author in many international journals and an author of 2 Kluwer arbitration practical insights on costs in international commercial arbitration. With that, over to you, Dr. Zivkovic. I hope I pronounced your name correctly.
That's perfect. Thank you so much. Can you confirm you can hear me?
Yes, we can hear you well.
Okay, perfect. Thank you so much for such a kind introduction. I am honored to be here today, and I want to thank the Asian International Arbitration Center and all other organizers for inviting me. As you could see from this very short bio, costs in international commercial arbitration are a topic very dear to my heart. It was actually the topic of my PhD that I defended almost a decade ago. So I'm currently working, as it was said, on turning my PhD research into a monograph. And I was very excited to receive this invitation because I thought, what a fantastic opportunity to actually update that part of my work. Now, the excitement was too big for the results that followed because I was quite disappointed with the findings because not much has been changed in the meantime. And while Professor Sahani was talking, I was thinking, what an interesting area to work in with a disclosure and conflict of interest, because that definitely developed. But when it comes to the allocation of costs for the third-party funders and adverse costs payment and the security for cost application, unfortunately, it seems that certain characteristics of international commercial arbitration are still preventing more effective or efficient development. Now, whether that's actually, I said unfortunately, whether that's for good or for the bad, we are here to judge together. So what I'm going to do, I'm going to present on these 3 themes quite generally, and then I'm happy to have a discussion with everybody in the room at the end. So my topic actually covers three themes. One is the reimbursement of costs that are called funder's fee, that are paid to the funder by the funded party. So in a case where the funded party is successful in arbitration, whether they can claim and whether the tribunal has the power and will they allocate the funder's fee. The second topic is the question of adverse costs. So in a case where someone is using third-party funding, whether it is reasonable to expect that third-party funder will be liable for the adverse costs that might be allocated against the party using the funding. And finally, the question that was also mentioned by Professor Sahani, security for costs, because we deal in the sphere of the cost, to what extent a party having received third-party funding, to what extent that fact should be taken into account when deciding on the interim measure of security for costs. So not a small assignment, but let me start by saying that in 2016, the first question of whether the third-party funding fee can be reimbursable. Now, very limited in which jurisdiction can it be reimbursed or allocated to the losing party in arbitration was responded positively in the jurisdiction of England and Wales. And the case that probably everybody heard of was SR versus Norskott case. Now, what was the question in this particular case? Under the ICC rules, a single arbitrator in that particular case decided to allocate the funder's fee, which is the fee that funders charge beyond what they actually give as funds for running the proceedings. The single arbitrator decided to allocate that to be paid by the other side as part of adverse costs allocation. As we know, in international commercial arbitration, and focusing only on international commercial arbitration, we don't have any restrictions to apply the loser's pays or the costs follow the event principle. It's actually quite prevailing principle, and different factors can be taken into account to allocate costs. The decision came to the attention of a national court in the setting aside proceedings, and the court said that this is perfectly fine because it is within the discretion of tribunal, in this case, a single arbitrator. Now, the questions of public policy were, of course, raised, but what the court clearly stated was that these are now outdated because third-party funding is being an industry developed not only now for litigation, but for the past few decades also for the purposes of funding arbitration. I have not found a similar decision in another jurisdiction that confirms the same approach. However, if I speak about it doctrinally, I have to say I do agree with this particular approach if we read the arbitration rules in this particular case, but also if you read almost any arbitration rules and national acts dealing with arbitration, you will see that the provision on allocation of costs gives a lot of discretion to tribunals to decide how those costs are going to be allocated. So what we are used to see in litigation does not necessarily transfers or translates directly into arbitration. Quite the opposite. Arbitration is developing so-called moderated cost follow the event type of approach, and also the categories of costs are construed much more broadly. So in this particular case, third-party funders' fee was considered to be so-called other costs. Having read those rules and the decision, it seemed reasonable to assume that the arbitrator did not go beyond their mandate. Now, moving to adverse costs, and then if you have anything to share on this topic, I'm more than willing to hear, is the question of adverse costs payment by the third-party funder. So probably it was said, or it will be said throughout this workshop and today's event, is that when third-party funders decide to fund, in order to decide to fund a certain claim or a certain party in arbitration, they are actually scrutinizing the whole case to determine the likelihood of the success in arbitration, which means that not every claim will be funded without any scrutiny of the funder. And this is somewhere quantified between 60 and 75% of the likelihood when the funders are going to be interested in funding the claim. And why am I talking about this? It's going to become relevant when we talk about the liability for adverse costs. I also listed a few forms of control that funders can usually exercise under these funding agreements, and they are the obligation of the funded parties council to keep the funder posted on how the proceedings are running, the clarification of case details, suggesting alternative legal strategies, voicing the funded parties' choice of a counsel, deciding how the claim is managed by the parties' lawyers, and influencing the settlement negotiations. Now, keep that in mind, and let's first focus on adverse costs in litigation. And I'm going to talk about this very briefly, again, from the position of the jurisdiction of England and Wales. The question when asked before national courts in relation to funders being liable on an indemnity basis to pay the adverse costs that the funded party was found obligated to pay was actually decided positively. So we have Arkin case and we have Excalibur case, in which the court decided that the third-party funders were to be made jointly and severally liable to pay the defendant's costs on the action on an indemnity basis, and Arkin case actually limited the amount to the extent of the funding provided. Now, that's what is happening in litigation. But what happens in arbitration is, of course, the question becomes whether third party has access in any shape or form, either to enforce their rights or to be imposed certain obligations because of the cornerstone of international commercial arbitration, which is the arbitration agreement. As we know, the arbitration decisions rendered in international commercial arbitration have only inter partes effect, and the inclusion of any third party requires a development of multi-party joinder or consolidation theories. These do exist, but it is not something that we are used to in international commercial arbitration. And as we know, either from practice or if you only studied arbitration, it becomes quite complex to include non-signatories in the international commercial arbitration procedure. Now, why did I mention at the beginning the powers that third-party funders can have? Is because in some cases, even though they are not a party to an arbitration agreement, a theory can be constructed that they are the real party in interest because of the success fee that they usually get at the end of the successful claim. Now, I think that despite not having any regulation in place in terms of how exactly third-party funders could be found liable for adverse costs decisions, I don't think it's entirely impossible in those cases where they basically exercise a large amount of control that they have right to under the funding agreements. This has not been confirmed in practice. I do not have any case that I can, in arbitration and litigation, of course, it's a different story, that I can cite. However, knowing how theory also often feeds into the practice international commercial arbitration, this is not something that is impossible to construe, which also means that if a country is at the beginning of starting to regulate third-party funding, this is the moment to consider this question as well, because it would be much better to have it black and white regulated than actually leave it to the discretion of arbitral tribunals and eventually national courts. And finally, before we have a discussion, the other topic that I was asked to talk to, and Professor Sahani before me mentioned security for costs and the purpose of it. So what I want to focus on is basically whether this interim measure in any way should be dependent on the fact that one of the parties, usually claimant, has a third-party funder. Because if the conclusion on the second point is that the third-party funders, it can be difficult to find them liable or at all possible to pay the adverse cost, that leaves the other side in a position that they know that there is a possibility that claimant, let's call the party claimant because it's usually that procedural position, might have some financial difficulties, but at the same time they know that it might be difficult to enforce this against their funder. So should we take this into account when we are allocating or deciding on security for costs, which is basically security that the defendant, the respondent, will be able to get their costs back in case of success? The question is not the one easy to answer as anything when it comes to security for costs, but in my research, what I've done, I started researching first financial difficulties and to what extent does that make any impact on the deciding on security for costs. And the answer is that while it might be relevant, it should definitely not be the most decisive factor. Quite the opposite when it comes to funding. It's not usually that the financial difficulties are the reason to actually seek such funding, but in some cases, it's simply the maintenance of cash flow. So when deciding on allocating security for costs, arbitral tribunals are invited to consider third-party funding, and that is also connected to the topic of disclosure, which was the topic of the previous presentation. But at the same time, that should not be the most important factor to decide whether security for costs is to be awarded, because much more serious financial situations such as bankruptcy and insolvency often are not taken into account, or not to the extent that they are the decisive factor, because otherwise you might have a meritorious claim that is raised by one of the insolvent parties, and yet they might be proclaimed or declined access to justice because they cannot cover security for costs. One more thing before I finish, please bear in mind also that because of the scrutiny that third-party funders are conducting before they decide to fund a certain party, and they require quite high percentage, it is highly likely that party will also be successful in their claim. So that even more decreases the importance of third-party funding when it comes to thinking about security for costs. And with that, I think I'm quite on point with time. I'm happy to answer any questions from the floor. I cannot hear yet.
Can you hear me now? Could you hear me? Thank you.
Yes.
Yeah, you were talking about the debate whether the arbitrator has a power to order the funder to bear the cost of the opposing party. My question is that do you think that it would be better for legislation on third-party funding to incorporate that power specifically into the legislation so that it will avoid all this debate on the question of power? Thank you.
Thank you. That's a fantastic question. I think it is a policy decision, which means that whichever way the legislator goes, it will have certain benefits and unfortunately certain disadvantages. So legislating it will definitely bring more clarity. However, it might actually reduce the industry of third-party funding in that given jurisdiction. It might lead to third-party funders not accepting to fund unless or they increase the percentage of likelihood for success that they expect, or simply the parties avoid that particular jurisdiction to arbitrate. So as everything in international commercial arbitration is a matter of trends, just as within the last decade we sort of forgot about the public policy discussions we had at the beginning of the century, but it is a policy decision. So of course the benefits is legal certainty, legal clarity, everybody knows what is expected, and third-party funders can calculate that into their industry. So I know the answer is not straightforward, but Malaysia might as well be the first one in the trend, or to start the trend, as it happened with Hong Kong and Singapore when it comes to regulating third-party funding in arbitration. I hope that answers your question.
Good afternoon. I have a question for you. In Malaysia,
Mhm.
we have the third-party funding legislation as yet. I hope it comes soon. But unofficially, there's already third-party funding going on in the arbitral fraternity here. And one of the example I want to give is the relationship between the parent company and the subsidiary of a company. And the subsidiary is a litigant in an arbitration proceeding. The parent in the auditor's report make a general statement to say that they will fund all their the financial needs of all their subsidiary. And then this parent company went into some form of financial distress. In Malaysia, we call it the company gone into PN17. That means the government give notice, or the security commission give notice to this company that your company has financial irregularity and you must redress the irregularity within a year. And usually situations such as this imply financial distress. Now, one party who is the respondent in this arbitration asked for security for cost. In this parent company subsidiary relationship, the parent is not specifically a third-party funders. Is there any room to imply that the parent company is actually a third-party funders in order for the tribunal to direct security for cost? Yeah, that's the question.
Thank you so much to unpack in that one question. So talking about parent company and subsidiaries, there is the theory of group of companies in international commercial arbitration. Not very popular, however, not impossible to use it to include a non-signatory to the arbitration agreement into arbitration. So I think the right, or the one of the more reasonable approaches would be to include the parent company as a potential party in dispute. Now, when it comes to third-party funding, yes, the parent company could be considered a funder, however, not a professional funder. So that's why I'm talking, when I talked about control and what are the powers that a certain funder has over the process, it serves to bring them into the procedure itself, because only once we prove that a non-signatory has such control over the procedure, we can we actually discuss whether the arbitral tribunal has jurisdiction over, you know, granting certain measures or imposing certain obligations on them. So definitely the short answer would be that the group of companies as a theory could serve to bring in the parent company to the proceedings, funding or not, no funding. It's all about how much they control the proceedings. Had they not done that, if they didn't do that, in that particular case, it would be quite difficult to get them involved or get them liable, to be liable for any of the costs. Does that answer your question?
Yes, but we know in under company laws, every company are separate legal entities, and the parent company is a separate entity from the subsidiary. Even though they are a subsidiary, but there was no specific agreement to fund the arbitration. The only agreement is that the parent company had insert a statement in the auditor's report to say that they will fund the financial needs of the subsidiary. That's it. There was no specific reference to funding arbitration or of that nature. So now we have to decide whether to order the security for cost under these circumstances, because the parent company has gone financially distressed.
Okay, I see now. Okay, so coming back to the security for cost, I focused too much on the liability. So security for cost, in security for cost, this can be taken into account. So it's actually advisable to take into account any funding that was disclosed. It should not be the decisive factor. Now, how is that implemented? It's up to the discretion of the arbitral tribunal. But indications such as receiving funding, financial distress of the funder could be relevant for security for costs. That much I know. They should not be the decisive factor, but certainly they should be taken into account.
Thank you.
Hello, Dr. Sivaya. Since we brought up company law, I'm interested in finding out your views whether third-party funding should be considered for an insolvency regime as rescue financing. What would your thoughts be on that?
For insolvency regime, when we talk about insolvency, do we talk about bankruptcy? Just to know the terminology.
Yeah.
Okay, and rescue regime for those who want to pursue
Whether funding
claims?
is considered as rescue financing to initiate the arbitration, and then stand first in line for any damages that are being awarded.
So in bankruptcy, because that was my topic of before I started dealing with costs. So in bankruptcy, as far as I remember, the trustee or administrator, whatever we would like to call them in different jurisdictions, takes over all the claims and the control all over the proceedings. Now, litigation is an easy solution, whereas arbitration, it's questionable whether the norms when it comes to the stay of the proceedings of those claims that are challenged need to actually be stayed or not. Does the stay need to be applied? So I find it difficult to see at which point would a third-party funder come into the picture, because if they already funded the claim, the question would probably be whether they have a claim against the state. Whereas if they haven't expounded the claim, the question would be on trustee whether they want to proceed with the proceedings. So am I getting I don't see the connection where the third party funder actually gets into the whole picture. If I could get some clarification on that.
At the moment, I think the litigation funding will stand first in line as a rescue financier. So the
I
question,
see.
so if third-party funding now in arbitration, whether they should also stand first in line for financing the matter in the first place as a rescue financier
So in the priority line.
in a priority list.
That's beyond my expertise, and I'll be very, very open about that. But I'm happy to check, and with my colleagues dealing with bankruptcy and financial law, and maybe even come back on that. But I don't want to answer because that's a very good question, and that's a bankruptcy law question. Sorry to leave you without the answer. What I dealt with was mainly what happens with arbitration proceedings after bankruptcy commences, and to what extent the mandatory stay is actually applicable to those proceedings, and how private international law deals with that. But leave it with me. I'm happy to share with the organizers later on the conclusion, and then it can be shared more broadly.
Do we have any other questions from the floor? I believe that there are no further questions from the floor. Doctor, do you have any concluding remarks?
Nothing in particular. I'm happy to hear all these questions. It seems that the issues I was talking about are still quite alive and developing. If anyone has anything else to add or comment on my presentation, please contact me offline and we can take it from there. Thank you once again for inviting me. This gave me an opportunity to refresh my knowledge and to have interesting discussions about these issues once again.
With that, thank you very much, Dr. Zivkovic, for the thought-provoking session and for your time to be with us here today virtually. It is still very early in the morning in the UK. I hope you're okay. Thank you so much for joining.
No problem. Have a nice day.
Distinguished guests, ladies and gentlemen, we shall now proceed to the fifth and final session for today, entitled Access to Justice or Denial of Justice, the Role of Oversight and Regulatory Mechanisms in Third-Party Funding. Joining us virtually is Mr. James Clenchey, the speaker for this session. James Clenchey is a full-time international commercial arbitrator and an associate member of Six Palm Court Chambers in London. A solicitor in England and Wales since 1990, James was also an advocate at the Paris Bar from 1994 to 2008. He spent 20 years as a commercial disputes lawyer with Withers, HFW, and Stevenson Harwood, specializing in shipping, energy, and commodities. He was a registrar of the London Court of International Arbitration for 4 years, from 2008 to 2012. He is an aspiring full member and former honorary secretary of the London Maritime Arbitrators Association. From 2012 to 2014, James was a senior legal advisor at Thomas Miller Legal, responsible for assessing and managing claims for third-party funders and insurers. He was a member of the ICCA Queen Mary Task Force on Third-Party Funding in International Arbitration. His article, Navigating the Waters of Third-Party Funding in Arbitration, was published in Arbitration Journal, Volume 82. With that, over to you, Mr. Clenchey.
Thank you very much. Good afternoon, everybody. I hope you can all hear me. And I hope that you can see my slides. Can you confirm?
Yes, we can see your slides well.
Excellent. Thank you. Well, I'm truly honored to have been invited to participate in this important workshop. And you have already heard from other former colleagues of mine on the Queen Mary Task Force on third-party funding. And I'm sorry that the time difference has meant that I have not heard them myself. So please forgive me if there is a certain amount of repetition. But I expect that my perspective will be a bit different in some respects, and that I will have something different to say to you at in this final session. And the reason why is illustrated here. My background is in shipping and international trade. And those are the sectors which are the most productive of international commercial arbitrations worldwide. But they're also the sectors which are already well provided with funding for bringing and defending contractual claims. And that's through different kinds of insurance. Here's a photo of the Solitaire, not a very pretty ship, but an extremely expensive one, as was the dispute relating to it. It's a pipe-laying vessel, or at least it is now. It was originally built as a bulk carrier in 1972, 50 years ago, and its conversion in the 1990s was complicated, and it gave rise to a complicated arbitration. And that began in 1995 and was eventually concluded in 2006 with a settlement for a reported 350 million euros. Now, at the time, this was the biggest international arbitration ever in terms of the numbers of people involved in it, the numbers of hours they spent, and the costs that they ran up, if not in the amount of the claim, which was still pretty substantial. A substantial portion of the claimant ship owner's legal costs, which were estimated to be around 50 million pounds or 75 million US dollars, was paid by its legal cost insurer, Guard, the Norwegian insurer, who was reported to have capped its contribution after the combined legal fees of both sides were said to have reached 100 million pounds. It's about 150 million US dollars back in 2006. It was understood at the time that after the tribunal had held a number of hearings and issued a number of awards, and there was still no end in sight, Guard insisted that the claimant and its lawyers find a quicker solution to close the dispute. Guard's sort of spend is the stuff of dreams for the new brand of third-party funders who tend to focus on investment and project disputes, arbitrations in institutional arbitrations such as ICSID and the ICC. The Solitaire was an LMAA arbitration, so under the rules of the London Maritime Arbitrators Association, an ad hoc arbitration. Guard is a mutual insurer, a protection and indemnity or P&I club, and its defense cover is designed to support members with contractual claims, usually in arbitration. And here's Guard's description of that cover. In shipping disputes, including buying and selling ships and shipbuilding, in which the disputes can run into the hundreds of millions of dollars, it is usual for at least one party to have its costs paid by an insurer. Defense cover was introduced back in the 19th century to protect ship owners who often had just one ship against the big commodities trading houses. These days, the ship owners may have more resources, but legal cost insurance has become part of the landscape. It's a way of reducing legal spend, keeping within budget, and of having expertise in handling cases. Like all insurers, the clubs are subject to regulation of various kinds, for example, in relation to their solvency. But there is no regulation in relation to their involvement in international arbitration. They continue to play an extremely important part in that. When I joined the LCIA, the London Court of International Arbitration, as its registrar, I was surprised by how many cases were being conducted without funding by third parties, such as insurers. As I say, my background has been in shipping and international trade, where funding by third parties, usually insurers, was normal. I discovered that many parties were able to access arbitral justice from their own deep pockets. Many of the parties in LCA arbitration were big multinationals, sometimes oil majors, and they were states. But there were plenty of other parties who struggled. The unfunded claimant could, frankly, be a menace. I remember one in-house lawyer who bombarded me with threats and said he was going to report me to Interpol because he said I was an international criminal. Reason being that I had informed him that the LCA court had taken the decision to treat the claim as withdrawn for non-payment of advances of costs. The prevalence of funding by insurers is one of the main reasons why London maritime arbitration sees more cases every year than any other form of international commercial arbitration worldwide. This graph, and the one that you'll see on the next slide, confirm the position. The LMAA's caseload is generally around twice the size of the ICC's. And as I have illustrated with the Solitaire case, many of those cases are enormous. Many are very small as well, but there's the full range. SIAC in Singapore, the Singapore International Arbitration Center, attracts increasing numbers of international commercial arbitrations, notably in commodities disputes, including export from Malaysia. But as you can see from this slide, it falls behind the LCIA when it comes to the appointment of tribunals in the arbitrations which it registers. You will see that there's been a big contrast between the number of cases filed on the previous slide and the number which actually reached tribunals on this slide. Indeed, for 2023, SIAC has reported that it had 663 new cases registered with it, but only 359 appointments of arbitrators. That contrasts with 3,268 appointments in LMAA arbitrations in the same year. More than half of SIAC's new arbitrations didn't reach the hands of tribunals. Why is that? Well, one of the main reasons is cost. Parties are put off by the directions to pay substantial advances on costs before a tribunal is appointed. Costs can be covered by insurance. And here I've set out a list of the various types of insurance that are routinely involved in international commercial arbitration. And the most important for purposes of our discussions today are legal expenses insurance, the insurance that covers not the claim, not the defense, but the costs, the legal costs, including experts' costs of bringing a claim. And so I've spoken to you about GUARD, which is a defense club, a freight, demurrage, or FDD club. But there are other kinds of insurance. Contract protection insurance is the equivalent in commercial transactions. There is political risk insurance, which can help a party to avoid having to bring a claim against the state. The insurer itself then takes over any such claim. There is liability insurance, such as P&I. There's general risks insurance, where the insurer will generally become subrogated in the claim, and in common law jurisdictions, a subrogated insurer has to sue in the name of its insured. So the existence of the insurance may not be disclosed at the outset, not in English proceedings anyway. And then we have after the event insurance, which is a specialized form of insurance that deals with costs. It usually deals with the potential liability to pay the other side's costs, but own costs insurance is also available. Many different kinds of insurance then help parties to mitigate their risks and to resolve their disputes. And it's the widespread use of insurance that was one of the reasons why the Law Commission in the UK recommended a relaxation of the laws relating to maintenance and champerty in 1967. The Commission recognized that insurers' influence in litigation beneficial and in the interests of the administration of justice. I was asked to join the ICA Queen Mary Task Force in 2016, 3 years after it was established. The co-chairs had recognized that they did not have anybody on the task force experienced in the funding of claims by insurers. I was pleased to join, but I was unprepared for just how little the task force knew about the quiet majority of international commercial arbitrations. Their expertise tended to be in big projects and investment arbitration, in which multinationals such as oil majors and states paid for the costs of arbitration themselves. I came to realize that members of the task force were anxious about the involvement of any third party standing between a lawyer and its client. This was one of their main objections to third-party funders. They were surprised to hear that insurers could exert a level of control over a claim. Instead of questioning whether they should be so worried about that, they decided that insurance should come within the scope of their definition of third-party funding for the purposes of their recommendations for regulation. This decision was reached without expanding the task force to embrace insurers, and, as is recognized in the ICA Queen Mary Task Force report, without real consultation with users of insurance. The rationale was said to be that the arrival of third-party funding gave rise to an urgent need for review and regulation. Here is the task force's working definition of third-party funding. I was a member of the definition subcommittee, but I have to say that I don't find the definition, which was finalized and with which I did not agree, to be very satisfactory. What, for example, is material support in A, in order to provide material support or to finance part of the costs of legal proceedings? What does in exchange for reimbursement mean in B? The history of that is that when I pointed out that insurers don't take a share of the in any dispute, they don't make money out of a dispute, they make money by there not being disputes that come within their policy. But another member of the task force said that, well, insurers could benefit from receiving reimbursement of their costs if they were to win. Well, yes, if the insured party receives a cost order in its favor, then the insurer should be able to recoup that. But it's not making money that way. Nevertheless, the notion of reimbursement came in so that the definition of third-party funding here includes insurers who provide finance in return, in exchange, it says, for reimbursement. Providing a service in exchange for reimbursement is not a business model. Anyway, insurance is explicitly there also because it was recognized that, in fact, an insurer's services are provided in return for a premium. So in return for a premium payment was included at the end of the definition. But the task force recognized eventually that it was actually biting off more than it could chew, and that there were indeed hundreds of international commercial arbitrations every year financed by insurers in the maritime sector. And that, apart from me, there was no one on the task force with any expertise in that area. Also, that such arbitrations had proceeded undisturbed for well over 100 years without any need for the kind of regulation that the task force was proposing. So the task force decided that it would make an exception for maritime arbitration. But maritime arbitration appears all over the place in different institutions, at different seats. Institutions don't make exceptions for maritime arbitration. They don't tend to divide up their caseloads. Governments, when they're legislating on arbitration, don't make exceptions for maritime arbitration. They treat all arbitrations in the same way. Under the UNCITRAL model law, maritime arbitration is an integral part of international commercial arbitration. The LCIA, the London Court of International Arbitration, unlike some other arbitral institutions, has not introduced any rules about third-party funding. It has been quite explicit about not wanting to alienate the defense clubs and other insurers and funders. The Law Commission in the UK decided against regulating funding in its recent review of the Arbitration Act 1996. It considered that the problems which third-party funding was alleged to raise were not new or unique to it, and were all capable of being resolved by arbitral tribunals under the existing law. So with that background, what is the definition used for third-party funding in the AIAC rules? Well, Rule 12 has this definition: the party that is funded by a third party in relation to the proceedings and or its outcome shall disclose the existence of the funding and the identity of the funder. That, I'm afraid, is a very wide definition. It would include an insurer. It makes no exception for maritime cases. The rule requires that the funded party disclose the existence of the funding and the identity of the funder. A party could therefore find itself obliged to disclose that it had, for example, trade credit insurance, even though a trade credit insurance policy would typically forbid it from disclosing the existence of the policy. The party would then find itself with two conflicting obligations. Why should it have to make such a disclosure? The first reason given by the task force for the disclosure of insurance is that an arbitrator may own significant stock in an insurance company. The task force in its report and in its deliberation, has not provided any evidence that such an arbitrator exists. I very much doubt that they do. That the drive to regulate was overtaking reality at this point. And I have to say that I think it is unfortunate that the AIAC and other institutions, not including the LCIA so far, have followed the task force down this path. Why was there such a demand to regulate third-party funding? Well, third-party funding, which is different from insurance insofar as the third-party funder looks to make a profit from a successful case, taking a share of the proceeds of the arbitration. It has certain features and has caused concern. The task force and others have looked to regulate it, but regulate what exactly? What problems are specific to it and need regulation? What is the motivation for that regulation? And how is that regulation to be performed? There are 3 C's, and the first one is conflict of interest. I believe that you've already heard, I hope you have, from Professor Victoria Shahani today about conflicts of interest issues. It's not something that is generally dealt with by statute or by regulation. The IBA guidelines are widely followed in international arbitration. They deal with third-party funding and insurance together, requiring an arbitrator to disclose any relationship with any person or entity with a direct economic interest in, or a duty to indemnify a party for, the award to be rendered in the arbitration. A direct economic interest is not explained, and it's a rather vague term. But a duty to indemnify is clearly a liability insurance or any other insurance under which the insurer is obliged to pay the insured to indemnify it. This definition wouldn't include before the event insurance, such as defense club cover, in which the insurer's interest in collecting the premium and not having to pay for the costs, and it doesn't take any share of the proceeds. It has no direct economic interest in the outcome. It's for that reason that a club like GUARD keeps a close eye on the proceedings which it is paying for. It keeps a close eye, it controls the cost of the proceedings as far as it can, because it's got nothing to gain from those proceedings being protracted. It has nothing to gain from a win. The second C is control of the claim. In England, the Court of Appeal has confirmed in Excalibur and Texas Keystone in 2017 that a responsible third-party funder must follow the proceedings closely. The court said litigation funding is an accepted and judicially sanctioned activity perceived to be in the public interest. What the trial judge characterized as rigorous analysis of law, facts, and witnesses, consideration of proportionality, and review at appropriate intervals is what is to be expected of a responsible funder and cannot of itself be champetous. The Court of Appeal criticized the Association of Litigation Funders, whose code of conduct did not require funders to take rigorous steps short of champity, in the court's words. The court's decision is clear. Funders must get involved. They must seek updates. They must assess the merits. They must be on top of the case, because lawyers in charge of the case can pursue a claim which it would be obvious to the funder and to others observing has no hope of concluding in a satisfactory way, and that unnecessary costs will be incurred. In that case, a cost order was made against the third-party funder, and it was an indemnity cost order. That is to say, it had to pay 100% of the cost, because it was held to have been responsible for allowing the cost to be run up to that extent by not paying attention to what was going on in the case. Third-party funders, in other words, must be involved. They cannot be gamblers sitting on the side, just taking a risk. The Singapore Institute of Arbitrators guidelines for third-party funding similarly fail to impose a duty on funders to take rigorous steps short of champity. And in my view, this is a serious omission, because Singapore has not updated its law on champity in the same way as the English courts have. So it does not have a decision equivalent to Excalibur. There is no precedent in the courts there imposing a duty on funders to be involved, to take rigorous steps short of champity. Regulation in a common law country which has not updated its law on champity in the way that the English courts have has to take account, in my view, of the developments of the common law in this area. Finally, the third C, costs. This is the area in which legislation can most realistically intervene. It can set a cap on the funder's percentage of its success fee. And this has been proposed in England in the wake of the Post Office Horizon case here. The sub-postmasters brought a successful class action with the help of the funder Therium, who I know has a different reputation in Malaysia. But in the UK, the funding by Therium enabled the sub-postmasters to bring the injustices that had been done to them by the post office to the attention of the courts, and then subsequently to the wider public, and to the extent that the government has now instituted a compensation scheme that goes beyond what the sub-postmasters in that class action were able to recover. However, in that action itself, the claimants, the sub-postmasters, are said only to have been able to recover after the funders, their share, after other unrecoverable costs. They've only been able to recover around 20% of the awards that were made in their favor. This has caused concern, and it has given rise to suggestions that the proportion of proceeds that funders are able to recover should be made that much lower. And this chimes as well with proposals in the European Union, where, as you may know, there's a draft EU regulation. One of the main tenets of which is that the funders' recovery should be capped. The EU proposed regulation also includes a recommendation that once a funder has taken on a case, it should not be able to withdraw halfway through. It should not let the claimants down, is the idea. So funders would not be allowed the discretion which a defense club has. And that brings me right back at the end of this talk to the very beginning of my talk. As I told you at the beginning, GARD was reported to have set a limit on its contribution quite late on, when it realized what was happening, that the case was not reaching its end. And that imposition of a cap precipitated the settlement. Regulation which doesn't allow national decision-making of that kind would risk jeopardizing the attractiveness of third-party funding for investors. As things stand in the UK, there is no regulation of third-party funding, whether through legislation or otherwise. But we may shortly expect it, clearly in relation to consumer actions in the courts and in relation to the amount that the third-party funder can recover on the proceeds of litigation. The common law, in the meantime, has set out clear principles for post-Champety conduct by funders. And that, although it's arisen in court cases, that is the common law, and it should be applied in London-seated arbitrations. So my recommendation for Malaysia would be to look at that case law that is developed in England and not follow the EU proposals, which come from different traditions and viewpoints, and which, in my view, would not be workable in international arbitration. I hope to have given you some ideas about the issues surrounding regulation, and I thank you very much for your attention, and shall of course be pleased to take any questions. If you would like to follow up on anything that I have said, I have written, apart from the article kindly mentioned in the introduction, I've written a number of other articles and blog posts, and you can find those on my insurance and funding page of my website. So please do look at that if you're interested. I would now be pleased to take any questions. Thank you.
I believe there are no further questions from the floor, Mr. Klanchi. And with that,
you.
thank you so much for being with us today virtually.
Pleasure.
Thank you for your time as well.
Well, thank you very much. It was a pleasure. Thank you.
Thank you. Distinguished guests, ladies and gentlemen, with that, we have come to the end of the workshop. Once again, we would like to thank our esteemed speakers for the insightful sessions, and we look forward to future opportunities of hosting you physically at the AIAC. Sincere appreciation to our collaborating partner, the Legal Affairs Division of the Prime Minister's Department, Malaysia, and our supporting organizations, the Inns of Court Malaysia, the Malaysian Institute of Arbitrators, Chartered Institute of Arbitrators Malaysia Branch, and Borneo International Center for Arbitration and Mediation, BICAM, for your unwavering commitment. We hope that throughout the workshop, you have gained some valuable insights on the intricacies of the third-party funding regime and the issues and challenges to take into consideration in regulating third-party funding moving forward. We hope to see you again tomorrow in our KL webinar for a deeper dive into the corporate world of third-party litigation funding and the global efforts in cultivating professional responsibility in this growing industry. Without taking much more of your time, please join us for some light refreshments next door. And with that, thank you so much and have a good evening ahead.